Okay, so chapter 3, agency, brokerage, and ethical considerations. In this chapter, we're going to identify the different types of agency and fiduciary responsibilities. We're going to describe the broker-salesperson relationships and discuss compensation issues. We're going to discuss disclosures to sellers and buyers relating to creating agency and providing material information. We're going to learn what material information is. We're going to describe misrepresentation, talk about the Consumer Fraud Act, antitrust laws, which some of them we already went over in chapter 2. We're going to talk about ethical considerations and disciplinary offenses, which some of them we already went over in chapter 2, and as forms of consumer protections. So let's start off. What is brokerage? Well, brokerage is defined as the business of bringing buyers and sellers and landlords and tenants together. In exchange, we receive compensation for those services. Brokers are licensed to assist others in real estate transactions, and salespeople are representatives of brokers and can be paid through them. So, who can charge the public fees for brokerage services rendered? Only the broker. So, how do we do it? Well, we're able to do it once we're employed for a broker. We're a representative of that broker. They allow us to charge the public for those services in their name. Okay? So, I put together this slide. This is not anywhere here in your book. I put together this slide. It's just who the players are. Okay, it's just a little guide of who the players are. So let's just go through it let's just run down through it really quick. Salesperson, well, that's the license you guys are probably trying to get right now, right? Salesperson is a real estate licensee who works under a sponsoring broker. A principal, that's what we call the clients, the one we're working for. We also refer to them as the principal sometimes. Agent is a licensee who owes fiduciary duties to clients. Fiduciary duties are legal responsibilities, and we're going to learn those legal responsibilities and what those fiduciary duties are in this chapter. Subagent, well, sub means beneath, right? So it's an agent of an agent is a subagent. They're both usually representing the same client. A buyer's agent only represents the buyer. A seller's agent only represents the seller. A disclosed dual agent, dual meaning both, two, is the agency, represents both parties in the transaction, and they can't place one party's interest above the other. So if you're representing two parties in a transaction, you can't play favorites and put one party's interest above the other. You got to treat everybody fairly and honestly. Now, this is a new type of agency here in New Jersey called designated agents. So in the past, if you have a brokerage firm that has one agent representing both clients, the buyer and the seller, it's dual agency. It's also dual agency if you have two agents working for the same brokerage, one representing the seller, one representing the buyer. That is still dual agency because they fall under the same roof. They're working under the same roof and under the same broker. So the broker, both of those clients are the brokers. Remember, anybody that you represent, you call them my client, okay? They're not your client. You are a representative of the broker. And any clients that you work with are actually the broker's clients. Remember, who's the only one that can charge the public fees for the services performed? Only the broker. You're doing it because you work for that broker. Think of yourself as the broker's big toe, okay? You're attached to that broker. And you can't, that big toe, if you cut it off, that big toe can't do nothing on its own. You need to be attached to the broker in order to do anything, okay? It's the same line of thinking here, okay? Now, the broker can get around with the big toe. It's just harder to do. They stumble or they roll around a little bit, right? But the big toe is not going to go anywhere without the broker, okay? So think of it that way. So A designated agent. This is a new type of agency where you can have two separate agents working at the same brokerage firm. And in this particular instance, with this new type of agency that was just introduced to New Jersey, the broker can assign one of their agents to only work with the buyer and another one to only work with the seller. These two agents should not share information that their clients told them in private, because you're only representing the seller and you're only representing the buyer. The broker's in the middle, so the broker represents both. The broker is still a dual agent, but each one of their designated agents, you've been designated to only work with the buyer, or you've been designated by your broker to only work with the seller. So you're only still going to work exclusively as a seller's agent or a buyer's agent only. So you got two agents in the same office, one working only with the buyer, one working only with the seller, but the broker, since they have knowledge about everything going on in their office, they're still a dual agent. But their job as a broker is to make sure that those two agents keep it separate and don't share information, because you're supposed to be representing only the seller or only the buyer. Okay? Not supposed to have access to privileged information from the other side. That's designated agency. And it's basically that simple. Don't overthink these concepts. These concepts are fairly simple, so don't overthink them and make them more complicated than they need to be. Transaction broker. Whoa, doesn't have the word agent there. Nothing in the law says that if a licensee, a real estate licensee, has to work with somebody in an agency capacity that has that word agent, buyer's agent, seller's agent, disclosed dual agent, or designated agent. You could just work with somebody in a transaction and not be working in an agency capacity. What does that mean? Well, if you're working as an agent, a licensee who works as an agent owes fiduciary duties to clients, those legal responsibilities. If you work as a transaction broker with somebody, you're acting as a manager of the transaction without having those legal responsibilities to the person you're working with. So, without getting too deep into that rabbit hole right now, because we didn't go over what those fiduciary duties are, just understand that transaction brokers don't have these legal responsibilities that an agent does. So they therefore don't represent anyone. They just act as the manager of the transaction, and they do the same thing that agents do in the real estate transaction process, but they're not owing anybody these legal responsibilities. So transaction brokers, the people they work for, are not referred to as clients. They're referred to as customers. So what's the difference between a customer and a client, you may ask? Well, I got the word commission in between there, so let me go over that word first, and then I'll discuss the difference between a client and a customer. Commissions are the compensation that we're paid for the work that we do, period. Client is anyone we're representing as their agent, and we owe them these legal responsibilities we call fiduciary duties. A customer, we do not have an agency relationship with customers. So like somebody walks in the front door into our office and they start asking us questions, we're representing them. So who are they to us at this point? They're just a customer, right? But once we enter into agreements with them and contracts and stuff like that, now they're our clients. So anyone we do not have an agency relationship with and are not representing them as buyers, as a buyer's agent, seller's agent, disclosed dual agent, or a designated agent. However, we still need to treat everybody fairly and honestly in the transaction. So we don't owe fiduciary duties to customers. We only owe fiduciary duties to clients. So who's a customer and who's a client? We're going to get into that in the coming slides, but I'll just give you a quick little rundown right now. I'll give you, if you're working as a buyer's agent, that buyer's your client. Now, the seller's agent, who is their client to you? They're a customer. You don't owe them fiduciary duties, but you still need to treat them fairly and honestly. Okay. So, page 30, let's do a little highlighting here. These notes are not great to highlight, but it's the best wording the book has got. You know, I'm working with the book manufacturer and doing a rewrite of this book, and hopefully they'll accept some better wording on this stuff. But they say a client is someone whom specific duties are owed. What do we call those duties? Fiduciary duties. And a customer is whom the agent is required to treat fairly and honestly. And then I wrote this part in there, which you should as well in your book. We do not owe customers fiduciary duties we owe to clients. We do not owe customers fiduciary duties owed to clients.
Fiduciaries is like a legal duties, right?
Correct. The legal responsibilities that we have to those we represent. And we'll go over what those fiduciary duties are in this chapter in the coming slides. I don't want to go over them just yet. We'll be going over them shortly.
Client to whom specific duties owes. Buyer was the agent. So client can be seller or buyer, right?
Correct.
And customer whom the agent was required to.
They could be a seller, buyer, landlord, or tenant. You know, anytime you hear me talking about seller or buyer, because it's just the usual, clients that we work with here. But they could also be a landlord or a tenant as well. So if I say seller or buyer, I'm also including landlords and tenants. Okay.
Okay. Yeah.
All right. So let's see. The creation of agency. What creates the agency relationship? Well, the creation of this agency is determined not by who pays the commission, but by a contractual agreement between the broker and the buyer, seller, landlord, or tenant. So we enter into some kind of a written agreement with them that we're going to be representing them. And we owe them certain obligations, but they also owe us certain obligations that they have to do. So as they say here, agency relationships have become more complex. A prospective buyer or person seeking a property to rent can also be a principal and hire a broker to act as the buyer's broker or buyer's agent. In this type of relationship, the buyer is the client, the person whom specific duties are owed. And the seller is the agent's customer, whom the agent must simply treat fairly and honestly, because we're not representing them. Now, it's also possible for a licensee to function as a transaction broker, working with the buyer, the seller, or both, without representing either, but functioning as the manager of the transaction. In this case, no agency relationship is created. So you should write something down there like this, or at least have this note that I wrote here. Transaction brokers should have a written contract, a BSA, we call it, a brokerage service agreement, that explains what we're doing in exchange for the fees we're earning. All right.
Writing it down.
Sure. So transaction brokers should have a written contract, just like agents. We call it a BSA. This is something that's new now in New Jersey, brokerage service agreement. It's new in the fact that it must be used. In the past, it was optional. So transaction brokers should have a written contract, a BSA, brokerage service agreement. That's what a BSA is. That explains what they're doing in exchange for the fee they're charging.
What? A.
What they're doing in exchange for the fee they are charged or charging.
Exchange for a B.
And while you do that, I'll just make sure I got all that stuff in our Word document there. Notes.
Yeah, earned. Earned. Transaction brokers should have a written contract, broker service agreement. That explain what they are doing in exchange for the fee that is charged.
And because, on those Word documents, I have a little bit more room than we have on the slides here to do the presentation. I'll just show you really quick. It's where we have the brokerage roles, that slide that I made up, where I explain what a salesperson, principal, what all these people do. I gave a little bit deeper
Okay.
explanation,
Nice.
like for the transaction broker, I wrote, they're a manager of the transaction without representing the principal in an agency capacity as their agent, and therefore does not owe fiduciary duties like an agent would. Their principal is called a customer. Transaction brokers should have a written contract, BSA, brokerage service agreement, that explains what they're doing in exchange for the fee that they're charged or charging or earning. Okay. All right. So, client versus customer. What's the difference between a client and a customer? Whoop. Let me make sure I put you guys back to that screen. There you go. As you can see, I also have this in the class Word document. So, a client is someone the licensee is representing as their agent and owes fiduciary duties. Those are the legal obligations we owe to clients. So who's considered a client? Anyone the licensee is working with as a buyer's agent, seller's agent, disclosed dual agent, or designated agent. The key word there, agent. If you're working with somebody as their agent, you owe them legal responsibilities. Now, a customer is someone the licensee is working with as a transaction broker, not as their agent. Or they could be another agent's client. Who are they to you? To us, they're a customer. Customers, we must treat fairly and honestly. We cannot lie to them. We owe them fair and honest dealing. That's it. We do not owe fiduciary duties to customers. Okay? Keep it simple. I like the KISS concept when it comes to learning. Keep it. Anybody ever hear that? The KISS concept stands for keep it simple, stupid. Keep it simple, stupid. So don't make me think. So don't overthink these explanations. Keep it simple, stupid. That's my learning. That's the way I like to learn things. Keep it simple, stupid. Okay. Now, fiduciary duties are the legal responsibilities we owe to clients. If violated, we can be held legally and financially liable to our clients. Okay? So, I guess these fiduciary duty things are pretty important. So, let's get to learning about them. Yeah. Go ahead.
Can I tell, this might be very, I don't know what kind of question I'm asking, but if I am a licensed real estate person, can I tell my buyer, if I am helping my buyer to get the house, can I tell my buyer as a client or customer?
I don't know. How are you working with them?
Oh.
It depends how you're working with them and what determines a checkbox on a piece of paper. What did you choose? How do you choose to work with them? Do you want to represent them? Work with them as the buyer's agent. If not, work with them as a transaction broker. Simple as that.
Oh, client, if you go with, if it's a client, you go with the rules and regulations, like all duties.
Well, fiduciary duties. We got regulations for everybody, but there's certain legal obligations we owe to our clients. Customers are not owed those same legal obligations of representation. So we're going to learn in the coming slides here. We're going to now get into what those fiduciary duties are, because wouldn't you want to know what your legal responsibilities are to someone you're representing? So we're going to learn about them in just a moment. But your question was more along the lines of, how do I know if this person's a client or a customer that I'm working with? Well, a checkbox. You filled out a contract with them. You're either going to represent them as an agent or as a transaction broker. So you could go showing them houses, help them get financing, show them houses, prepare the contracts. The difference is in the paperwork. Did you check off that you were going to have legal responsibilities that you owed to them, that you're representing their best interest? Or do you not want to be bothered with that? You're just going to be acting as the manager of the transaction, helping them do that stuff, but you don't want to owe them any legal obligations. Then you'd be working as a transaction broker. So boom, it's just a checkbox. Okay, it's paperwork, but it's required. Because I think you missed it on the second day there, but in chapter 2, if you review that video there for chapter 2, for the recording of the class, where we went over this, the CIS form is the Consumer Information Statement. This is the first document we give to anyone we intend to do business with. It explains to the public the different ways that we could work with them as a buyer's agent only, seller's agent only, disclosed dual agent, or a designated agent, or as a transaction broker. So it explains the different types of business relationships that are possible. And as of now, how do we plan on working with you? So we'll fill out now a brokerage service agreement that says we're either going to work with you as an agent or as a transaction broker, how much we're going to get paid, and who's paying it to us. Okay, right. And what are we going to be doing for you in exchange for that fee, and what the customer or client's obligation is to us for this transaction? It's all covered in that brokerage service agreement.
I see.
Okay, so agency. The role of a broker as an agent of the principal is a fiduciary relationship that falls within the requirements of the laws of agency. We owe fiduciary duties to our clients when we work as an agent. Once again, buyer's agent, seller's agent, disclosed dual agent, or designated agent, but not when we work as a transaction broker. So, fiduciary relationship. Okay, we should know the definition of this. What is a fiduciary relationship? We discussed that we owe fiduciary duties to somebody, so what is a fiduciary relationship? A fiduciary relationship is based on trust and confidence, in which an agent's responsible for the money and or property of others. For example, you're working with somebody, they give you money, what do you got to do with it right away? You got to safeguard it. You turn it over to the broker immediately so that they could put in the escrow books, and then they deposit it in the bank account. So because we're a fiduciary, we're responsible for that. So we're responsible for their money and or property. We conduct an open house. We open up the house to the public to walk in and check out this house that's for sale. We have an obligation to make sure nobody goes walking out with the TV. Right? We're responsible for that because we opened it up to the public. We're responsible for the property. We need to safeguard their property. It requires putting the client's interest above all others, including our own and our broker's own. See, in the book and on exams, they usually say you got to put your client's interest above all others, including your brokers, assuming that you know that you're a representative of your broker and you put your broker's interest always first because you're working for them. However, when it comes to your client's interests go above everybody's, including your brokers. I just like to make it a little more personal, and I say including your own. And let me give you an example of this. You got a buyer. You found them a house. They're under contract. You did all the inspections and everything. We're ready to close next week. And you can't wait because, you got to make that car payment. I need that money. I got to make the car payment. But now you find out something that was not uncovered during the home inspection. You found out some information. Do you keep your mouth shut about it just so that you could close on time and get your commission and you could pay your bill? Or do you disclose it to your client and possibly risk the transaction? Well,
Disclose to client.
That's right. You got to disclose. Put your client's interest above all others, including your own. You got to look out for your client's best interest. You got to that's what representing someone's all about. All right. So here's the highlight that you did in the book. My definition, slightly different than the others, because I think the book manufacturer, I think somebody who helped with one of those previous rewrites, redid their definition of fiduciary relationship slightly to more resemble the one that I had. I think it was one of my old instructors, actually. they kind of stole my definition. They put it in the book. But my definition is still a little bit more different than that. So I tweaked it a little bit more. Now, what do you call the agent who has fiduciary duties to someone? We call them a fiduciary. So a fiduciary is an agent who owes fiduciary duties, those legal responsibilities. And a fiduciary relationship is one that is based on trust and confidence, where an agent's responsible for the money and property of others. It requires you putting your client's interest above all others, including your own. Okay? And we owe those clients fiduciary duties. And so therefore that makes us a fiduciary. All right. Here's the messy notes from the book. Now, you can see these lighter highlights. There's notes in there. That's not in the book. This is what I suggest that you write there in the book, okay? So highlight the general agent, do the underline, special agent, do all these highlights and write these notes. And then we're going to go to the next slide where it's a lot neater and you could take a screenshot of it if you like.
Property.
So above general agent, you should write scope of authority is defined in the property management agreement. And above where it says special agent, you should write most agents function as special agents.
Okay. Got it.
Okay. I'm going to get a cleaner screenshot from my book. I'm going to update this slideshow with a cleaner screenshot from my notes, which seem to be a little bit neater in my book. All right. So power of attorney. What is a power of attorney? We're first going to start with that, which is actually at the top of page 31. A power of attorney is a document that grants someone the authority to legally act on our behalf as if we're standing in the room signing documents ourselves. The person that's given the authority to act on our behalf and sign those documents is acting as our agent, referred to as an attorney in fact, when in fact they're not an attorney. And they must operate according to the limits that were of the authority, the scope of the authority that was granted to them in the power of attorney document. So what do I mean by that? A power of attorney is a legal document that gives someone else the authority to sign documents on your behalf, as if you signed them yourself. But you would put limitations on what kind of documents they could sign on your behalf, wouldn't you? Or would you allow them to cash out your bank account, open life insurance policies, buy cars in your name and stuff like that? No, you would limit the scope of the authority that they gave you, that you gave them. So that's what I mean with that explanation then. So that's the basics of a power of attorney. Now, a universal agent is someone who is given an unlimited power of attorney.
Wow.
They could sign on all matters.
Anything, right.
Yeah. I mean, you may do that, give that to maybe your relative, like if you have and I don't even know if you would do that. You may create something else like a living trust or a living will, like if you get into an accident, you become brain dead, you want your sister or your brother maybe to make the decision if they're going to keep you on life support or pull the plug, right? That kind of a thing, that's a universal agent. They got the authority to act on your behalf on all matters to make those decisions. Now, a real estate agent will work in one of two ways, either as a general agent or a special agent. Will be a universal agent. So what is a general agent, and who usually works as a general agent? What kind of real estate agent works as a general agent? Well, property managers. If you're in a property management, if you're getting into the property management field of real estate, property managers usually work as general agents. So what does that mean? That means they can legally bind their clients to a contract within the limited scope of authority that the owner has given to them in their employment agreement, which we call the property management agreement. That's actually their limited power of attorney, is their employment agreement, that property management agreement. It grants that property manager the authority to legally bind the owner of the property in certain ways that they may have given you permission to. Like, for example, if you're a property manager, one job may be filling vacancies and finding tenants, right? For those vacancies. But you have to sign the lease contract with that new tenant, legally binding the owner of the property to the new tenant? Maybe. It depends what it says in the property management agreement. It depends on what that scope of authority is that they passed on to you. Does that make sense? Okay. And then most agents work as special agents. We're going to get into the next slide into that a little bit more. But general agent, it's important to understand that concept. So what can a general agent do? They can legally bind their clients to contracts within the scope of authority that was granted to them by the property owner in their property management agreement, which is their limited power of attorney. So who works as a general agent? Property manager. Everybody good? Any questions?
General agent, property manager usually work as a general agent. For example, can we have example who can be a general agent?
Well, property managers are. If you're one
Properties man.
manager managing someone's property, you're going to work as a general agent. The owner of that property will tell you if they're going to allow you to sign contracts. They'll say, hey, listen, part of your duty is not just to maintain the grounds and deal with the snow removal and landscapers to cut the grass, but part of your duty is also, if we have vacancies, to get us tenants to fill those vacancies so that we make money. That's your job as a
Wow.
property manager. But for you to sign the lease with the tenant, or does the owner need to sign the lease with the tenant? Are they going to give you that authority to sign a contract, a lease contract with a tenant, legally binding that tenant to the property owner? It depends. What does it depend on? What it says in the property management agreement. Because the property management agreement is your power of attorney that would have granted you that authority. Make sense?
Property man.
You good?
Can you repeat one? Can you repeat one more time? Property managers are.
Yeah, that's a mouthful. Okay, so the property manager is the one who works as a general agent. And what can a general agent do that a special agent cannot? They can legally bind their clients to contracts. Okay, so they'll be signing. The example I gave was they'll sign a lease on behalf of the owner, legally binding that tenant to the owner to rent their property.
Okay.
Now, the owner may not want that. If that's the case, then we cannot sign the lease on behalf of the owner. We'd have to give the lease to the tenant to sign, and then we'd have to give it to the owner to sign. But I tell you what, most owners, they don't want to micromanage and deal with that. They don't want to deal with tenants. That's why they hired you as a property manager.
I see. Got
Okay.
it.
They usually give you the power of attorney to sign them contracts with those tenants, to select those tenants.
Got
Okay.
it.
Okay, now, so what about special agents? Most real estate agents don't work in property management. Okay. Most real estate agents are just dealing with buyers and sellers and landlords and tenants to hook them up with a rental, but we're not managing the property, the rental property. So we just earn our commission on the fly real quick. We're not ongoing with the management of the property. So most agents work as special agents. They can represent the principal in one capacity only. That's the wording that's often used on exams. What does that mean, one capacity only? I'm going to tell you. It means you cannot legally bind your client to a contract. Anytime you see the term that is an agent can work in one capacity only, that only means that you can't legally bind them to a contract like a general agent can.
Mm.
So what can a general agent do that a special agent can't? They can legally bind their clients to contracts. But if you ever see this weird wording on exams, the agent can work in one capacity only, that just means they cannot legally bind them to a contract. Because a lot of times students get confused with this, because when they say one capacity, you can only represent them in one capacity only. A lot of times people start thinking, even me back in the day, I was thinking, well, what does that mean? That you can only represent the seller and not the buyer?
Mm.
No, that's not what it means. It means that if you're representing the seller, you cannot legally bind them to the contract. You can work with both the seller and the buyer and not be able to legally bind either one of them to a contract. Right? So what is that? An example is, if you got a listing, you signed listing contracts and agreements with the owner of a property, you agreed on what the listing price was going to be. Now a buyer comes in and they make an offer that you know is acceptable to the seller. Can you sign that contract on behalf of the seller? Or do you need to forward that contract to the seller to sign and decide for themselves if they're going to accept it and then sign it? You have to forward to the owner. And
Second one.
let them decide and then sign. We cannot sign sales contracts for sellers. We cannot sign a buyer's contract and offer for the buyer. We got to let them sign. That's what we mean by a special agent can work in one capacity only. So usually if you're dealing with sellers and buyers or landlords and tenants and you're not a property manager, you're going to be working as a special agent. That simply means you cannot legally bind them to a contract. You could work in one capacity only. I was hired to market the property and find a ready, willing, and able buyer. That's all I was hired to do. Now that we got the buyer, the seller needs to sign the contract and decide if they want to accept it or not. Because we need to forward or present all offers to sellers within 24 hours. So
Can you repeat one more time? What do you say? 24 hours what?
I have it written down here in the bottom of the slide. So we'll get to it right now again.
Okay. Oh yeah, it's right there. Sorry.
As a buyer's agent, you can help the buyer find a property, but you cannot sign and submit an offer on the buyer's behalf, legally binding them to the contract. And as a seller's agent, you can market the property to find a ready, willing, and able buyer. But you cannot legally accept and bind the seller to any offer. We must forward the offer to the seller within 24 hours. And then the seller decides whether they want to reject it, make a counter offer, or sign the contract and accept it. That's what I was saying. Okay. So here's another slide I threw together. The book kind of sort of says this stuff, but it doesn't say it point blank and directly like these couple of slides that I made are. What is a power of attorney? And then we need to know what a special agent is and what the difference between a general agent and a special agent is. Okay, so a general agent can legally bind their clients to a contract within the scope of their authority as defined in the property management agreement. So let me make a little fine tuning to that. Period. Property managers work as general agents. So special agents, most agents work as special agents. You're very special. Okay. You cannot legally bind your client to a contract. That's all it means. They must forward and present all written offers to the seller to sign them if they wish to accept them within 24 hours. So all special agents work in one capacity only in that regard. So you'll probably get a question on exams. You need to know the difference between a general agent and special agent. General agents can legally bind clients to a contract. Special agents cannot. Who works as a general agent that can legally bind their clients to a contract? Property managers. We also update that in the class Word document here. Excuse me. All right, so now we're going to get into those legal obligations that we have to our clients. We call them fiduciary duties. What are our fiduciary duties that we owe to clients? Well, here's an acronym to remember them. It's spelled COALD, COLD. Stands for care, obedience, accounting, loyalty, which includes confidentiality, and disclosure, which includes notice. So we're going to go over each one of these fiduciary duties now. Now, I put a little note here for you. Disclose dual agents when we're representing both parties in the transaction must not place one client's interest above another. Transaction brokers do not owe any fiduciary duties to the customer they're working with. They only owe fair and honest dealing. Just modifying the Word document to have the same look about it here.
What happen if you cannot open the slides? This is why I'm asking. When I study on weekend, I just want to know if any Google Drive slide cannot open, what can be the thing that I can do?
You should be able to open all these slides. If you have any problem,
Really?
yeah,
Oh, okay.
they're PowerPoint. It's PowerPoint. And if you don't have PowerPoint, you could download another presentation app that should be able to open up PowerPoint slides. If you have Google, do you use Gmail at all? If you
Yes.
do, you can open it directly within Google itself. Just save it to your own drive, though, because otherwise, it tries to limit the traffic, I think, by opening up so many slides. If everybody's opening it up from my saved drive here, if everybody's trying to do this at the same time, it could have issues, And I've had a lot of students, not just from this class, but many other classes, all trying to open up stuff right now at the same time. I don't know, So it's easier just to download them and then open them up. You could use Gmail. Gmail has a suite of tools for presentations, and you can open it up directly through their app. Or you could get one of the open suites of applications that are free out there that you could use to download PowerPoint. Open up PowerPoint stuff.
I see.
We also have the Word document as well. Okay, so now okay, I have that there. Let me just open up my snippet tool. I want to add a screenshot to the notes here.
It just says that could not preview the file. You may be offline or limit connectivity. Try downloading instead. I can open chapter 1, 2, everything, but third chapter not opening. Fourth, I cannot open. Some open, some are not.
You know why?
Right.
It's a huge file.
Oh, so?
So you're basically trying to open up a really big file, and it's not able to just stream it open. You need to download the whole file to open it. Otherwise, it's difficult to open because chapter 3 is a very big chapter, and I have videos in it. I have all kinds of stuff like that. So if you're just trying to open it directly from the drive, yeah, you may have an issue.
I see.
Okay.
I'm gonna do that.
Why? That's the reasoning why. Okay.
Okay.
What are your fiduciary duties? Code. Care, obedience, accounting, loyalty, disclosure.
Goody.
Okay, everybody do it. I want everybody to tell me, what are your fiduciary duties? Come on, become like a choir. I want you all to sing it in unison together. Care. Oh, here, I'll be the band leader. I'll set the pace here. Care, obedience, accounting, loyalty, disclosure. Come on, everybody at once. Come on, unmute your mics. I want everybody to say it.
Care, obedience, accounting, loyalty, disclosure.
Keep doing it. Why we got one person doing it? Come on, everybody here.
Care, obedience, accounting, loyalty, disclosure.
I know this stuff. I need you guys to memorize it because we're going to go over each one of these fiduciary duties so that you can understand them. But first, you may get a question on exam just simply to know what the fiduciary duties are. So you need to memorize this list: care, obedience, loyalty, disclosure. Care, obedience, accounting, loyalty, disclosure. Keep saying it in your head until you get it. Care, obedience, accounting, loyalty, disclosure. You need to memorize it.
It has to be in the
same order?
Yeah.
No, this is just the order that I'm teaching it in.
Okay, got it. Okay.
Easiest way to remember. Because watch, I'm going to change the slide right now. And some
Mhm.
other books and some other instructors prefer a different acronym to teach it to you.
I see. Okay.
It sound cool by saying old car.
Oh, okay.
Old
Old
car.
car is another acronym. It may sound cool, but I think it's a little bit more difficult to remember because it's a little bit more involved. Um, Obedience, loyalty, disclosure, confidentiality, accountability, and reasonable care and diligence. It doesn't like flow off the tongue, smoothly too. Obedience, you must obey your client's lawful instructions. Loyalty, you must always act in your client's best interests, even if it means foregoing your own. Disclosure, you must disclose all the information to your clients. Confidentiality, you
You
must keep
must keep.
their private information private. If they tell you anything in confidence, like, hey, I'm willing to pay more for this house, or I'm willing to accept less,
Mhm.
you can't go disclosing that to other parties. They told you that in confidence. You got to keep your mouth shut about that.
Mm.
Accountability. You must be accountable to your clients for all their funds, their money, and property that's been entrusted to you.
Mm.
And reasonable care and diligence. You must use reasonable care and diligence in performing your duties. All right. How do I get Zoom's controls off to the side? Come on, Zoom. Let me stick you off to the side.
You are right. Now I can open it. I just wanted to check it out. Is it open or not?
Yeah. Yeah, there's no problem in open. It's usually just because of
It's
the
a used file, right? Yeah. Now I can open it.
open it from online from the drive. If it's a big file, you may have issues.
Download it and yeah.
Yeah, just download it and then you can open it. All right, so let me grab this screenshot here as well from this so I can add to the slideshow here. Or not the slideshow, but the Word document. All right, good. So those are your fiduciary duties. So now we're going to get into them one at a time. Here's another screenshot that has them both on the same screen. All right, let me grab a screenshot of this one too.
Oh, okay. Old car.
If you guys are using Apple, I'm sure Apple has its own tool for this, but I use what do you call it? A Windows computer. So Windows comes with what we call a snippet tool. If you go to the search window and you just type in SN, it should come up for the snippet tool, or you type the whole thing, snippet tool. And it's kind of like a free screen grab tool that allows you to take screenshots of the slides in images. So you get a good, clear image instead of trying to take a picture with your cell phone. And then, you get those wavy, distorted looks to it a little bit.
Oh, okay. So NIP, yeah.
Yeah, so if you I know Apple has a tool like that as well. I'm just giving you guys a
No,
tip.
I am using it. Yeah.
If you're taking screenshots at all, I'm just showing you another way that you guys can get them. All right. Okay, so care, obedience, accounting, loyalty, which includes confidentiality, and disclosure, which includes notice. You may want to write in the book there notice because it's not written there as well. Because disclosure includes notice. And here, I'll give you a basic rundown of these, and then we're going to get into each one in a little more detail.
So we have to remember, excuse me, we have to remember both. All are same, but only the old car has one more. Those are 5 and these are 6.
Old car is the same thing. Look, care. So reasonable care and diligence. Well, that's care. Okay. Accountability. That's accounting.
Yeah.
Disclosure. That's the same. Loyalty, that's the same. Obedience, that's the same. What's difference here? Oh, confidentiality. Well, loyalty includes confidentiality. You must keep your clients' confidential information.
Yeah. Oh, it's the same thing, but they used to. Okay.
Yeah, you got to be loyal to your client's interest. If they take
Right.
confidence and you go blabbing it, are you being loyal? So confidentiality. Over here, it spells it out as a separate one, but it's really the same thing. Okay.
A quick question might be they can ask anyway. We just have to remember this five, all of them.
Yeah.
Yeah.
There are obedience, accounting, loyalty, which includes confidentiality, and disclosure, which also includes notice. Okay.
Yeah.
Also just easier to remember. Cold, care, obedience, accounting, loyalty, disclosure. It rolls off the tongue a little bit easier, you know.
Right, right.
This is another way that, you know, some teachers teach it because old car sounds cool, but the order and trying to remember it's a little bit more of a task for the mind to grasp there. So we're going to go over each one of these right now. Let's start off with care. But before I move to the next slide and start off with care, picture yourself a real estate agent.
Mhm.
You want to get a listing from your friend, or maybe a house, and you want them to work with you. And you tell them, yeah, don't worry, I'll take care of you. And you give them that little nudge, you know, don't worry, I got you, I'll take care of you. What does that mean to you? What does care mean? I want to see what you guys' take on it is. You're not going to find it in the book here anywhere. So what does care mean to you?
Like I will help you out. I will perform all my rules and regulation duties.
Hey,
So
hold
don't
on.
worry.
Sorry. You're a real estate agent. You want your friend to use you. And you say, yeah, come on, use me. I'll take care of you. Well, are you going to be taking care of me in some other way than another agent would? What does that mean, take care? I mean, we often use these words very flippantly, you know, I got you. I'll take care of you. But if someone were to actually call you out on it and say, what does that mean to care for me?
You you had trust
They
some
put me on the spot, right? Go ahead. What are you saying, Raphael? Sorry.
there's a trust to you had trust someone to the right thing.
Well, I hope any agent I hire I should be able to trust.
Can be
Yeah, I'm really coming at you. Go ahead.
so because you trust because you're going to be take care and they don't harm to you.
Well, how are you caring for me? Put on a spot. It's kind of, I know what it means to care for somebody, but now they're trying to ask me, what does that mean? You know, the definition is actually not that complicated. You guys are here taking a class, and every day you attend class, you're learning more and more information that the regular public is not privy to, right? So if you use that information to help your clients, you're caring for them. So additional education and experience. So any classes you take, you learn information. If you actually use that information to help someone, you're caring for them. Don't just be a seminar junkie taking classes, but then keeping that information in here and not actually applying it. Because if you do have the knowledge of something and you don't actually apply it, that could work against you in the eyes of the court. The eyes of the law say that, you know, if you have knowledge on something and you did not use that knowledge to help the person, you were careless. Or let me use another word there, negligent. So care, here's the definition we put on slide over here. Care is providing the best service possible to your clients using the knowledge acquired through education and experience. So the more sales that you do, the more experience you have. Different transactions come across, different issues come up in different transactions. And once you've experienced them, you learned how to work through them. Now, the next client, the next time you have that situation, you have the knowledge, you know how to work through it. So if you apply that information through your last experience you had when you did this once before, now you're caring for your client because you have the knowledge on how to resolve the issue, right? Not all two real estate transactions are the same. You know, they have their different little issues that come up. So caring for your client is using that knowledge and experience, the knowledge that you're learning here in class and applying it to help your clients, and the knowledge that you're gaining through actual on-the-job experience. If you're using that to help your clients, that's caring for them. It's a pretty simple concept, but you know, when they put you on the spot, trying to think of it, you're like, I know what care means, but you know, I've been there. I know, but that's why I want to make a point by doing this. Courts will hold an agent to a higher standard of care, more education and experience not possessed by the average person. Let me see. Courts will hold an agent to a higher standard of care with more education and experience not possessed by the average person. Breaching this duty would be careless or negligent in your representation of your client's best interest. So that's your first fiduciary duty of care.
Right.
Just grabbing my snippet tool. I like the way these screenshots look instead of just putting the words. I'm also going to add some screenshots from these slides there. Give you a little breakup with imagery. There we go. So that's care. Now, we're going to take it a step forward and actually read this one. Now, I don't sit there reading the whole book to you, as you guys see already. We're going over slides and, you know, I tell you to highlight stuff and I explain things and then we go on to the next thing. In the issue of care here, however, I'm going to read it and go over it. The other fiduciary duties, we'll kind of skim through a little bit more and just give you the explanation because there's a lot here under care. So, under breach of duty of care, you guys can read along with me or watch it on the screen here. A real estate agent's expected to deliver quality of service that a normal person would expect of a reasonably prudent agent. Actions breaching this obligation may be failure to present a written offer before it expires. Hold the phone. Do offers expire? I mean, I know if we have a written offer, we have to forward or present it within 24 hours. But if we don't, does the offer expire? No, it doesn't. So what are they talking about here? Well, you could actually write an expiration date on this offer in the contract. You can make an exploding offer, you could call it, where this offer is good for, we're putting this offer out there for the seller. It's good for 48 hours. So, seller's agent, you have an obligation to present this to your owner within 24 hours. You know, they got another 24 hours to get back to us if they want it accepted or not. If they accept it or not. We don't want you holding on to it for a week, waiting for the weekend to come along so that you could hold an open house to see if you could get any other offers and then pit offers together to start getting, you know, negotiations and bidding wars going on. You know, with a real live client here, we're making an offer today. You either accept it or we're moving on. That's basically what you're saying. So you could actually write into your contracts when you're making your offers that this offer is good for 48 hours from the time that we present it, the time that we send it over to the other agent. You could put that information down there. And let's see. Neglecting to mention in the purchase contract any fixtures or personal property desired by one of the parties. Is there anything illegal about that? When you make an offer asking if the seller can include, say, the washer and dryer, even though it's not specifically included in the listing? Because the washer and dryer is their personal property, right? Could you ask that it be included in the sale? Is there anything wrong with that? Asking the seller if they can include throw in the washer and dryer?
Yeah, we can ask.
Sure. There's nothing wrong with that. There's nothing illegal about that. But if your client asks you to do that and then you don't do it, are you caring for them? You're violating your fiduciary duty of care. They ask you simply to do something, right? That's also, I think that would also fall under the fiduciary duty of obedience. Even though you're not a dog, you must obey your client's lawful instructions. And them asking you to see if those fixtures can be included, there's nothing wrong with that. So ask. But if you don't ask, you're not doing what you're supposed to. Neglecting property being managed for another. Improperly handling escrow deposits. Your clients give you money, what do you got to do with it? Your clients give you money or a check as a deposit. What do you got to do with it? Come on, guys.
Give it,
Your broker.
we'll give it to broker.
Put it in the escrow account and do their escrow bookkeeping, and they got to put it in the escrow account within 5 business days of the time that you got it from your client. Okay, it's not within 5 days of acceptance of an offer. It's within 5 days of you accepting that money from your client. Don't mix those two up. You can't hold on to the money, wait to see if the offer gets accepted before you give it to the broker. Because when you submit an offer to a seller, you're supplying them a copy of the check that they gave you. And you're telling them that we're in possession of that money. We deposited it in our escrow account. So if you're saying that, but that money's not in the escrow account, you're lying. So even though you don't owe fiduciary duties to the other party, we still need to treat them fairly and honestly. You could be held legally and financially liable to the other party for the money that you don't have. Okay, so failure to obtain all necessary signatures on a contract. Okay, so we got a couple that's buying a house together. They both need to sign. Not just the one that's got the good credit, because the lender is going to want both of their information on there anyway. Plus, check their IDs. Check the IDs of anybody that you ever have sign a contract, even if it's a seller inviting you into their home to list their property for sale. I need to check your IDs to see who you are. Because I checked the tax records first before I came here to see who's listed as the legal owner. So now I'm going to need to check your IDs to make sure that you're actually the legal owner that is trying to list their property for sale with me. I'm telling you this because I had a situation once, and I tell every one of my classes this story. It was in Springfield, in Union County, in Springfield. I had a married couple. They invited me into their home to list the property for sale. And from the second I walked into the door to the time they guided me to the dining room table where we were filling out the paperwork, or we were about to fill out the paperwork, before I sat down, because once I walked into that house and I started walking to that table, I had a little voice in the back of my head that was nagging me saying, check their IDs, check their IDs, check their IDs. Now, I normally don't hear voices, but I had this nagging little voice in the back of my head saying to check their IDs. And previously, I never checked anybody's ID when I was invited into their house to get a listing. You know, it wasn't a part of my practice. It was just an oddball thing. This little voice in the back of my head, check their IDs, check their IDs. So I go to sit down, but before I sit down, I said, oh, before we get started here, guys, you know, you got to do it in like a nonchalant way. Don't make a big issue about it. Just say, hey, guys, before we get started here, I'm just going to need to see your IDs really quick, like your driver's license, okay? Before we get started here, signing all this paperwork. So, you know, the husband, he reached in his wallet, pulled out his driver's license. I looked at it. Looked at the name, looked at the picture, looked at him, gave it back to him. I'm like, okay. And the wife, she's all running around looking for her pocketbook. She's like, I think I left it in my car. So then she goes outside and I'm BSing with the husband and BSing with the husband and BSing with the husband. And then I'm like, what happened? Would she get lost out there or something? So I stand up and start walking towards the door to check, and he walks, he's walking with me asking questions and such, which in a way it seemed kind of odd. It seemed like he was trying to slow me down or something, you know. And I looked outside, she left.
Oh, wow.
So I said, what's going on here? I said she was looking for her ID. She thought she left her pocketbook in her car and she left. And this is what the guy's response was. This is what he did. He was like, well, it's not really my wife, it's my girlfriend. I'm getting divorced, and she's just such a bitch. She doesn't want to sign any documents, and she doesn't want. I was like, oh God. I'm thinking to myself, oh my God. I wasn't doing this facial reaction, but I was like, oh, yeah, this is what you got to deal with sometimes, and it's a oddball situation, So I asked him, I was like, what do you think was going to happen here? You were going to have your girlfriend forge your wife's signature so that you could list the property for sale? What would happen if an offer came in? Are you going to have her forge the contract as well? That's illegal. You guys can go to jail for this.
Mm.
You know that when you have a real estate transaction and it gets down to the closing table, whoever the closing agent is, whether it's a title company or an attorney, they're required by law to check the IDs at closing. So if I took this listing and I never asked for your ID and we got all the way down to that closing table, the buyer would have had money into their paying for attorney review, for paying for title search and survey, getting homeowners insurance, getting an appraisal done on the property. They're into thousands of dollars already into purchasing this house. You don't think you're going to get sued if they find out at the end of the day where they're ready to close and buy the house and they're already packed up, ready to move out of their other place, moving into this place, and they find out that you're not really the owner, that you don't really have the right to sell the house? You don't think they're going to sue you, your girlfriend posing as the wife, the attorneys, both real estate agents involved? Everybody's getting sued. They're going to throw lawsuits at the wall and see what sticks. That would have been a horrible situation. So I'm also thinking this, as I'm explaining to him, I'm also thinking this, and I'm like, Scooby-Doo moment, like all of my history of all my past transactions I've ever done in my life. I'm like, oh my God, this could have happened I'm like reviewing like all the transactions I've ever had. I'm like, holy, this could have happened to me in the past. It's amazing that this never happened before, because I never checked anybody's ID. So as a practice after that, what do you think I do now?
You check it out.
Check IDs. I always ask for IDs. I don't care. You're inviting me into your home. You assume the person whose home you're entering, that they actually own it. But, in this case, it was one guy, but, the girl wasn't, so check IDs. I even told you guys to do this as new agents, a way that you could seem like you're more professional at open houses. Remember, I told you that little tip? Don't just let people sign into open houses. Ask people for their IDs. You may get some pushback from them. They may be like, well, nobody ever asked me for IDs before. Why are you asking me for my ID at an open house? You're discriminating against me.
Huh.
I'm sorry, you never had an agent ask you for an ID before? And in most cases, you're probably never going to have people who say, yeah, they asked for my ID. If they ever did, they're probably one of my students, because I've never come across it before where an agent asked for somebody's ID at an open house. I tell my students that they should do this. It'll make you seem more professional than agents who have been licensed for years working in a business, because most of them don't do this. So I tell them, check for IDs. Ask for the ID. And with somebody, you want them to give you that kind of smack, that kind of attitude. Because then my response is to overact once again. I'm going to be like, really? You never had an agent ask you for your ID at an open house? Well, there's other agents out there are conducting their business, but I was hired by the city to conduct this open house. We got to look out for the property here. We can't just like open it up to the public and let people come in that we don't know who they are. You have to sign in a sign-in sheet. How do I know you're not just writing down some obscure name? We need to check the IDs. Really? You never had an agent ask for your ID before? Wow. Well, I don't know how those other agents are getting by conducting their business, but we look out for our clients when we represent our clients' best interests. So, are you currently working with a buyer's agent, Mr. and Mrs. Buyer, by the way? Because if you're not, I can provide the same level of service to you. Whoa, you see what I just did there? And it makes me seem so much more professional because everything I said is a legitimate great, right? Now they're complaining because no agent ever asked them for an ID, and I'm acting like I'm shocked. Really? Nobody ever asked you for IDs before? How do they conduct their business? So basically, I'm downplaying all those other agents as being crappy agents. At the same time, I'm elevating myself simply by asking for an ID. And you guys can do the same thing, being brand spanking new agents, but you got to play out the part. You got to act it. You got to be like, really? You never had an agent ask you for your ID before, and seem concerned about it. Well, I don't know how those other agents out there are conducting their business. I don't know how they can represent their client's best interest. Seller hires us to open a house. We need to know who we're opening it up to. Yeah. Go ahead, Daniela.
I went to like this lady and she told me that they don't check like IDs or anything.
Yeah.
And I told her like that like in the like school that I was like learning
Yeah.
that you guys told me to check like IDs and everything
Yep.
to
Because
make sure like they're not being no fraud or something like that.
I'm telling you, most agents never do it. They're never taught to. Me, I wasn't doing it until I came across this one experience where I had a little voice talking to me. The little voice in the back of my head taught me this lesson because I asked a question and I caught somebody. How amazing! We are the lottery numbers voice. I want to win that $1.7 billion or whatever the hell is the lottery right now, right? Come on, voice, talk to me. But it's the same thing. Most agents out there do not do this, but I had that little voice that spoke to me and it told me, and that was my learning experience when I caught them. It happened to be that little voice spoke to me, and when I listened to it and I asked for the ID, I caught them. And I used that as a learning lesson that flashed before my eyes, all the previous transactions I've ever done, that this could have happened, and thank God it did not. That could have been lawsuits. That could have been sanctions on your license. You could have had issues with the real estate commission over that. Go ahead. You could just ask a question. Put your hand down. Just ask questions. It's just like
I'm sorry.
we gotta open up. Go ahead.
So I know you saying that you check the ID, definitely. But even when I was looking for the house, so many houses that we check, we just sign it. But in open house, so many people come, right? They don't check ID. So might be because of this experience, might be you, but there are many agents out there. They don't check. There is a paper. We just have to sign this.
Open houses is different than the listing. The listing, I never. I
Listing.
IDs to sign the listing agreements. But even when you meet with buyers before you sign contracts, you should check their IDs. And
yeah, that is true. Yeah.
Of a pre-qualification or a pre-approval letter from the lender too, or a proof of funds letter if they're buying cash. But at open houses, this is an idea that I came up with years ago for my agents because I was hiring a lot of new agents, especially agents because they come attend my classes. Some of them ask, "Oh, do you have a brokerage? Oh, I'd like to sign up with you." So I used to hire a lot of brand new agents and to give them training. They're like, well, how do you, when you're dealing with all these other agents that have been in the business for so long, how do you compete? I'm like, well, be a professional, because somebody's been in the business for a long time. One thing that I've learned, first off, I'd say the second office, I really, really learned this lesson that I ever worked at. There's a lot of agents there. And there was such a lack of professionalism, and I really learned how on my own to try to, as a new agent who doesn't have more experience than these other agents that have been working in the business for years. Look, you guys are going to be out there. This first office you start working for, you may have agents, because there's always a couple of these idiots out there. You're gonna have agents that they're gonna actually like talk down to you, because they want to seem like they're right in conversations or arguments or whatever. So they're gonna be like, "How long have you been an agent?" And they're basically talking down to you, and don't back down to them. I'm teaching you stuff that you need to know to learn, right? And if you have that knowledge, you could stand right up to them and answer them. What does that have to do with this? That's like somebody talking from a position of authority, That's like saying, well, you can't discuss this topic because you don't have a college degree. Why, do I need a college degree to have common sense? Right? To have a conversation? It's the same type of thing. When people try talking from a level of authority, I've been an agent longer than you, but they don't say that. Instead, they talk down to you and say, hey, how long have you been an agent? Trying to belittle you, stand up to them, say, what does that have to do with this? This is the fact. You got to do this. Okay. So I learned that at an open.
I'm sorry to interrupt you.
Yeah.
So I gotta go to do something. So I'll be back in the afternoon.
Okay. Second.
See you this afternoon.
Let me give you your before lunch attendance poll there before you.
Please.
Okay. Wait, where the hell did the attendance polls go? Zoom. Oh, there we go. I swear, each time I log into Zoom, the attendance polls things move around. Okay. Wants to answer this? Yeah.
Thank you.
Okay.
Thank you.
Does everybody still want to answer that attendance poll?
Oh, yeah, sure.
We got one more person out there. Answer that attendance poll, please.
I did it.
Yeah, but we're waiting on one more person to answer it. I usually keep it out there. The attendance poll's up there, waiting for one more person. I usually give everybody a minute, shows you that's time to see if they're paying attention or not, before I close it out. But that's the thing, though. If you ask for that ID, to check the IDs there, and it'll just make you seem more professional at an open house. And now anybody that walks into that open house, now you could flip them into a possible buyer client that you're working for. So when you start working at a real estate brokerage, how do you get business? That's you know what? I want you to answer that now because that could be involved thing. Well, we can answer that a little bit later on in this chapter.
Right.
But one thing I'm going to say is, you start working at a brokerage, they probably have listings already. Go to whoever the listing agent is to be courteous and ask them. I mean, technically, you could go just to the broker, but go to whoever the listing agent is. Familiarize yourself with your office's listing inventory of properties, and talk to the listing agent and ask them if it's okay if you do an open house for their listing. You notice they got a listing, it seems nice, and you'd like to do an open house if that's okay with them. And then you could schedule it with the owners to do an open house. Now, you're not going to get any commission on the selling side because that's the listing agent's side. They're the ones getting the commission on it. But any potential buyer that walks in that door, if they buy that property, they're working with you, you'll get the commission from the buyer's side of the transaction. Now, most people do not buy the homes that they walk into off of the street at an open house. However, many of them do buy something. So even though they're not going to necessarily buy that house, you could introduce yourself, show them how professional you are, and help them, try to get them to work with you, and they'll be your buyer's client.
I see.
I did this when I started, and this helped me get my business without spending a penny. Just giving out business cards. I guess that's the only thing, right? I explained this. I showed my professionalism, and I got the buyers to work with me. And sometimes buyers when you start asking them questions, like, what's your urgency to sell? Do you have a time frame? Where do you live now? Are you renting or do you own? Maybe they have a house they need to sell. I've actually got listings by hosting an open house. People that walked in off the street, I convinced them to work with me as their buyer's agent, but I asked them where they live now, and they said, oh, well, we own a house. We still need to sell that. I'm like, do you have an agent for that yet? Because I can help you with that too. And boom, I got a listing. And now the listing agent who I did the open house for, all of a sudden they're all pissed off and bent out of shape because they're like, you get that listing, hosting that open house for you. Well, they do it. So I took the extra step, I took the initiative, and I got a listing out of it. So there you go. All right,
So
for that attendance poll that's open there, it's been open 4 minutes already. Nobody's answered it, or the one person can answer it. All right, I'll close it out.
so listing is like, let's say I want to have my property in list to sell it, right? So that once I have that agent, means to who help me out, if I give the money, that's 5 days. 5 days he has to escrow that money.
The broker needs to put it in the escrow account
Put
within.
it in the escrow, right? And what is that 3 days? Once that 3 days contract, that's
That's when people sign contracts. You have 3 days to. Once it's been signed by both parties, you have
okay.
Attorney review. So that's you have 3 days to start attorney review. Otherwise, the contract will become the attorney review is your opportunity to make changes to the contract or cancel it. If both parties sign the contract and you don't start attorney review within 3 business days, the contract becomes legally binding the way it's written.
And this 5 days is like if I do I put my property in listing.
5 days has to deal with, when you're showing somebody a property and they're interested in making an offer, we're talking about making an offer. They're going to give you a deposit with that to make an offer. And so typically it's at least $1,000. So what do you do? Just hold on to that money until the offer gets accepted? No. You give it to the broker. The broker needs to deposit it into the escrow account. They need to do some record keeping, who gave us the money, what it was for, what property it was for, what's the agent that's working with the client, all that information. So they can keep track of who that money's from that's in the escrow account. So they need to keep track of all money that goes in and comes out of the escrow account.
So they just have to put that money in 5 days.
Yes,
5 days.
correct.
Okay.
That's what that is. The broker needs to put that in the account within 5 days. So when they're making that offer, now that offer hasn't even been accepted yet. Your client you may not have even presented it yet because you just wrote it up. But the client gave you, so you give that money immediately to the broker. The broker does their record keeping, puts it in the bank account within 5 days of you getting that money. And now we got that offer we made. We're still waiting to hear back if they're accepting it or not. So there's the 3 days is for the attorney review once the contract's been accepted and signed.
Right.
Okay.
And another question is, you said that once that if you don't in the listing, if you don't ask for the ID, let's say you sign it and everything without ID, anybody. Later on, who's gonna penalize
you?
Everybody, like broker, realtor, everybody's gonna be penalized.
Everybody could be. If the broker, look, you're a representative of the broker, so you're going to get in trouble as well as the broker. The broker's job is to make sure you're doing your job right.
Right, right.
The broker's taking in a listing that their agent did wrong. They took a listing from somebody who wasn't even the owner.
Mm.
What would you do if you
Yeah,
And then-
if
need to start attorney review? And then you paid for an appraisal, and then you paid for home inspections. Now, let's just say it only gets that far, and then you find out that the person that you signed a contract with isn't even the owner.
oh,
You're going to want to sue somebody. You're going to want your money back because you're not going to be able to go forward with that transaction because that person's not even the owner, or you don't have all the owners on the same page willing to sell. But yet you laid out all that money. Somebody's getting sued. They should.
mm,
Somebody's probably also going to get reported to the real estate commission.
mm.
You think the real estate commission's not going to do anything if you're taking listings without from people who aren't even the owner?
Right.
Okay. Let's go back to the slide here. So,
Thank you.
signature one. Look, that sparked a lot of conversation, right?
Mhm.
To go over this a little bit and dive into this a little. So,
That's nice.
the duty of care requires a seller's agent to, among other things, be knowledgeable about all aspects of a property to arrive at a reasonable listing price. How do we arrive at a reasonable listing price? Well, we don't order appraisals. We wish a seller would pay for an appraisal to find out what the true value of their home is. But they're not going to spend the money to sell their home. They're like, let the buyer get an appraisal. Okay, so, but when we list the property, how do we know what value to list it at? Well, we as real estate professionals, we're going to learn how to value properties. And so you're going to do a CMA. It's called CMA, Comparative Market Analysis. It's similar to an appraisal, but we should never call it an appraisal. Reason being is we're not licensed appraisers. So therefore, we cannot do appraisals. However, we can do property valuations that we call CMAs, Comparative Market Analysis. And that's what we do for sellers to try to determine a reasonable asking price. And when we deal with buyers before they make an offer, it's not a bad idea to do a CMA for them. Make sure, you don't just say, what do we do, full offer price? Well, how do you know the full offer price isn't ridiculously overpriced? You got to do a CMA to figure out if they got it priced properly. Don't go in there as a real estate agent and say, let's make full offer price without even knowing if that's a reasonable asking price. So CMAs, we do them for sellers and buyers. And to be knowledgeable about all aspects of the property to arrive at a reasonable listing price, to discover and investigate material facts. Okay, so material facts, that's material information they're talking about there. Material information we're going to learn about in the coming slide in this chapter. It's usually information about the physical condition of a property that a buyer would place importance in wanting to know and could affect their decision in purchasing. It's not necessarily problems with the property. It could be something simple like how many bedrooms and bathrooms it has. Can that affect the buyer's decision in purchasing? Then we need to investigate and disclose it. It's a material fact. It's material information. What about the type of heating system and the heating fuel that's used? If it's oil versus gas versus propane or something else, right? Could that affect the buyer's decision in purchasing? Yes. So therefore, it's material information. We're required to investigate and disclose it to potential buyers. So the architectural style, that's the physical condition of the property, right? We're required to investigate and disclose this information. Okay. And another way that we could also find out material facts about a property, like maybe if were there any improvements that the seller ever did to this house? Are there any problems with the house? We have a seller fill out this document here on the left side of the slide here. It says the seller's property condition disclosure report. This is a document. This is a form that we use that was put together for us as a courtesy from the Realtors Association. However, you can create your own version of a seller's property condition disclosure report. In the past, it was always optional. With recent law changes, it is now mandatory that you use it. In the past, I always told sellers, and I still do tell sellers, that they need to fill this out. And they need to be honest when they fill out this form, disclosing any information you know about your house. That includes problems with the house or
Right.
improvements with the house. So all that information, there's a bunch of questions on this form about the roof, the heating systems, the plumbing, all that stuff. Okay, so I tell the sellers, the owners of the property, at the time I get a listing, I have them fill this out. I tell them, answer all the questions to the best of your knowledge and be truthful and honest. By doing this, we're going to present this form to any interested parties in your property. And then they're going to need to sign off acknowledging that they received the information you provided to them. Okay, now it's up to them to do whatever they want with that information. But you're honest in it. And by me having you fill out this form and you fill it out honestly and fully, I'm helping limit your liability in the event of a lawsuit. Nothing can prevent somebody from suing you. But I can, as your professional real estate agent, my job here is to help try to limit your liability. And having you fill out this form, I'm limiting your liability in the event of a lawsuit to actual damage costs. If you did not disclose to potential buyers information about your property, or you were dishonest about the information you put on this form, and somebody ends up suing you later on, a court can award them treble. Treble is triple the cost of the actual damages. So I'm helping you limit the liability. See what I did with that whole little spiel? I kind of memorized it. I do this spiel here to let people know what I'm doing for them. Because if you don't let them know what you're doing for them, my agent, they gave me a bunch of paperwork and forms to fill out. Don't even remember what it was about. The agent doesn't educate them what you're doing to help them. Oh yeah, they get paid a lot of commission, for what? I don't know, what they put that on them. That paper I gave you, if you were to educate them on everything that you're having them sign and why you're having them sign it, they could see now that you're doing a lot more for them than that that they may otherwise take for granted. Okay, so once again, I'm giving you training here on not just how to pass the exam. I'm actually giving you additional information here on how to present this stuff so you seem like you're more professional and how you could be a better agent than agents who have been in the business for years. Because most agents, they don't explain that to them. Actually, most agents probably don't even know that. You're limiting their liability in the event of a lawsuit. Okay? All they know is, here's a form that we need to fill out. So here, fill out this.
Question. I'm sorry to interrupt.
Go ahead.
Okay, you just said that as we have to tell seller to fill honestly whatever it is, even if it's problem, whatever you have to let us know in the form, right?
And
So,
then,
for example, I was helping my brother for the house. I went to that house to look at it. Everything was okay, but when we went to basement was leaking in the corner side, and I saw that, and I told that agent, the realtor, this is leaking, and he didn't know that. I said I had to let that person that what
Okay.
happened.
so now that agent knows that, they have to disclose it, that there's a leak.
Okay,
Okay.
but he didn't know that.
Yeah. Now, what is the leak from? Is it from a pipe? Is it from a crack in the wall? Is it coming in through through the walls? Where's it coming from? That's a different subject altogether. But either way, the seller should be told about it. If they already know about it, well, then they should have disclosed it on the seller property condition disclosure report here. Here, let me actually open up that form and I'll give you guys a peek of what's on it.
Yeah. Means what happens at that time he didn't know that. So after we usually when people leave, the agent gonna talk to that seller?
Well, the thing is, anytime that, let's just say the seller really didn't know about the leak. You
Oh.
discovered this leak and you told them, you made them aware of it for the first time.
Oh,
Okay.
I see.
So let's give
Okay.
a bit of the doubt there. If that's the
Mhm.
case, that's what's happening. We let them
Mhm.
know about it. There's an obligation now to disclose that information that there was a leak on the property. And if they repair the leak now, well, they still have an obligation to disclose the fact that there was a leak and what the situation was behind it. Okay, so let me I'm just looking for the seller's property condition disclosure statement here.
Means means what I'm thinking means I want to ask you at that time, if it's this kind of scenario, that time the buyer is not gonna think about that house. That I'm asking
Well,
because it's leaking.
goes away somewhere else. Okay, so but for future buyers, that the agent now is aware of a leak. The seller is now aware of a leak. They cannot keep that from future buyers. They're legally required to disclose it.
Okay.
Okay,
Means
so
legally disclose this means they know now, so they have to fix it, right?
well, they don't necessarily have to fix it, but they have to disclose it. If they don't fix it, it's up to future buyers. Do you want to buy a house that you know has a leak? That's up to them. The seller doesn't have to do any repairs on their house. They can be like, I'm selling my house as is. There's stuff that's messed up in the house. You want to buy it? You fix it.
Okay. So
Some-
disclose it means you're saying that in the form they have to disclose it, right?
Yep. Yeah, let me show you.
Yeah.
So you
Okay.
have to disclose it in some kind of property disclosure report. Now, that is always the law, that sellers have an obligation to disclose any known
Damage.
issues with the property. They're always required to disclose that. However, we as real estate agents, we're not always required to have a seller fill out some kind of a disclosure statement form. It is not because there is no official one that needs to be used. Some brokers were like, well, until the day that they pass a law and they make it that everybody needs to use the same disclosure statement, then because I can make a disclosure statement that has 2 questions on it. Well, if there's only 2 problems, then you only have 2 things to disclose, But so, yeah, that's true. But that broker had a chip on their shoulder, obviously, on this issue. And so they instructed none of their agents to ever fill out a seller's property condition disclosure. But by doing that, are they looking out for their client's best interest? I just explained to you, by having an owner fill out this report and do it so honestly, and then go through all the questions, how they answered it, and walk around the house and, to the best of my ability, confirm that that information is accurate as they've answered it on the statement. I'm helping limit their liability in the event of a lawsuit. All right. So that broker that had the chip on their shoulder that doesn't allow their agents to do this, well, they're not looking out for their client's best interests, even before it was mandatory. Now it is mandatory that we use some form of seller property condition disclosure. It doesn't need to even be particularly this one, just this version of it. Okay, so let me go over this form really quick. I'll just give you a quick little run.
Yeah.
Okay, so this is the seller's property condition disclosure statement. This is what it looks like. You guys, I'm focusing this on screen for you. You can see it now?
Yes.
Okay. So this is the New Jersey Realtors logo. This was created by the New Jersey Realtors Association. They dropped the word association and now they just call themselves New Jersey Realtors. So you put the property's address and the seller's information here, and then you cannot help the owner fill out this form. They have to fill it out on their own. Reason being, you don't know anything about their house. Okay, so
Who can fill up the form? Agent?
only the owner,
Owner fill up the form.
not you. You don't have any knowledge about this person's house.
Okay.
Right?
Oh yeah, of course. Yeah. They have to fill it in.
Yes, only the owner can fill it out. We're not supposed to help guide them on how to answer the questions.
Okay.
to try to get one over, which remember, we got to treat everybody fairly and honestly. That's why we're trying to disclose this information. Here, I guess we should start by reading this
Right.
thing, this section here. It says, the purpose of this disclosure statement is to disclose to the best of the seller's knowledge the condition of the property as a result, as of the date set forth below. The seller is aware that he or she is under an obligation to disclose any known material defects in the property, even if not addressed in this printed form. Because, this form doesn't have every possible question on
Right.
it.
Right.
So seller alone is the source of all the information contained in this form. That's why you can't help them fill it out. All prospective buyers of the property are cautioned to carefully inspect the property and to carefully inspect the surrounding area for any off-site conditions that may adversely affect the property. Moreover, the disclosure statement is not intended to be a substitute for prospective buyers hiring a qualified expert to inspect the property. If your property consists of multiple units, systems, and/or features, please provide complete answers on all such units, systems, and features, if the question is phrased in the singular, such as if it's a duplex and it has multiple furnaces, water heaters, or fireplaces. Okay, so now let's just get into this. So they got a bunch of questions about the occupancy. Do you know the age of the house? I mean, the answer options are yes, no, or unknown, right? Do you know the age of the house? If yes, write it here. If unknown, check unknown. So it's pretty easy to fill out. And sometimes if the answer options are yes, they want additional information. So you got questions here about occupancy. You got questions about the roof, basements, and crawl space. You got questions about termites and other wood-destroying insects, dry rot, and pests. Structural questions about the house. Questions about additions and remodeling. Questions about plumbing, water, and sewage. Questions about heating and air conditioning systems. Wood-burning stoves and fireplaces. Electrical systems. Questions about the land, the soil, the drainage, and the boundaries. Questions about any environmental hazards. Questions about deed restrictions and special designations, homeowners associations, condominiums, and cooperatives. Some miscellaneous questions. Questions about radon gas. Anybody know what that is? It's an invisible, odorless, tasteless gas that'll kill you. It causes cancer. It's one of the leading causes of death in the United States, actually. It's a leading cause of cancer, second to smoking, I think. They got questions here about major appliances that are included or excluded from the house or that are present in the house.
Right.
Questions about solar panels. A lot of questions about that since they're becoming popular. Questions about water intrusion. Okay, this is new. This has been added to this form. These questions about water intrusion. Although the one thing I don't like about it is they turn these more into political questions. Because climate change. They start talking about climate change, and a lot of this. Mandates that come from politicians to do stuff like this. They often talk about climate change and predictions that the sea levels are going to rise. That's all bullshit. There's no way for you to predict anything like that. In some places, in the planet Earth, sea levels rise. Other places, the sea levels fall. They said the polar ice cap is melting, but in the meantime now, we just found out that for all these last years that they were crying about climate change and all the ice melting, in the Arctic, we found out that there's hundreds of billions of tons of additional ice that have been formed, So which way is it? Are we going to go with the science consensus or are we going to do with the actual facts?
Actual facts.
Science does not consist of a consensus. There is no consensus for science. If that's the case, we would still know that the planet is flat. You know, we would know there's no such thing as gravity. Yeah. You have to ask questions in real science, right?
Right.
There's questions here about flood risks as well that have been added.
It's like a flood zone. If that area is flood zone, right?
Yep. But look, how they predicate these questions, they start off by talking about climate change. Look, flood risks in New Jersey are growing due to the effects of climate change. It's always changing, but you're talking about it in a specific way,
Right.
And so coastal and inland areas may experience significant flooding now and in the near future. They always have, including in places that were not previously known to flood. For example, by 2050, it is likely that the sea levels will rise or meet or exceed 2.1 feet above 200 levels. Really? Then why are all of these rich people buying beachfront properties? Right? Placing over 40,000 New Jersey properties at risk of permanent coastal flooding. In addition, it's amazing that they are allowed to make such claims. We would be sued if we made claims like that. We're not allowed to make claims like that as real estate licensees. I guess it's okay for them, politicians that are making this stuff up, right? So, in addition, precipitation intensity in New Jersey is increasing at levels significantly above historical trends. That is actually false. We have had times where we've had a lot of precipitation and less precipitation. And right now, we're not experiencing anything more than we ever have in the past. It's just we have storms sometimes. It's just that the current people that are alive are now experiencing them for the first time, and they think, oh, it's new. It's not new. It's new because they're telling us it's new. Placing inland properties at a greater risk of flash flooding. It's not a greater risk. You saw the other, last month and the month before, there was those flash floods in a couple places in the country, right? And they said, this is new because of climate change.
Right.
But in fact, if you went back to, 1950 or something like that, they had flash flooding like this that was even worse. So, is it new or is it new to you? And now you're going to, because you've got this agenda about climate change, so you're going to try to marry it to that agenda, right? But science is not a consensus, once again. Weather's always been changing. Sometimes we have disasters, natural disasters. Is it new because of the climate change? Prove it. A lot of these climate change activists can't even prove, how much carbon monoxide's in the air. So take everything that these experts say with a grain of salt. I know a lot of people in college, they're indoctrinated with this stuff, so they believe it as fact because they've been taught it since kindergarten now. But the weather's always been changing on this planet, Ask the dinosaurs. To learn more about the impacts, including the flood risks to the property, you got to have these flood disclosure statements now. And they just tie it to climate change, whatever. It's a disclosure we need to give. I don't go over there trying to educate everybody on the climate, I just say this is the law now, so you got to disclose this information. If you had floods in this area, if your area is prone to flooding, if you had any flooding that you're aware of.
Right.
As far as predicting where it's going to be flooding in the future, I'm not going to get involved in that. That's nonsense. So you got questions about flood risks. They added a lot, as you can see. And then that's it so far. They always update this every couple of years to include more questions.
I see.
So now the seller has to acknowledge, and then here's their opportunity to add in any additional information that they want to disclose. So then all of the sellers have to sign and date. And if the seller's dead, well, their executor, administrator, or trustee of their estate that's selling the property has to disclose the property to the information to the best of their knowledge. Now, they may have never been to this property, so everything may be unknown. And if that's the case, they still disclose to the best of their knowledge, and it's up to the buyer for your protection, get a home inspection, right? By a
Who
licensed,
can sign over there? This over here, who can sign?
huh? The
The
executor,
exec.
administrator, or trustee. So an executor is somebody who you named in a will to carry out your final wishes.
Okay, okay.
That you wrote in a will. If you did not name an executor in your will, the court will appoint somebody called an administrator to do those duties. Or if you have a
Okay.
family trust, well, that trustee. Okay. Now, receipts and acknowledgement by the buyer. Okay, so in here they tell the buyer, don't rely on just this information. Also, for your protection, get a home inspection by a licensed New Jersey home inspector, And for other issues, like if there's a pool in the house, things like that, these are not normal home inspections, so you would need to get yourself a pool expert to come in and give an inspection of the pool and all of its mechanicals. All right, so now you're going to have the buyers sign and date. And then both real estate agents will sign and date here. Now, this pertains to you. So the undersigned real estate, seller's real estate broker or broker salesperson acknowledges receipt of the property disclosure form, that information contained that was provided by the seller. The seller's real estate broker salesperson also confirms that they visually inspected the property with reasonable diligence to ascertain the accuracy of the information included in this report, prior to providing a copy of this statement to the buyer. So after the seller fills this out, walk around your house or the seller's house, and to the best of your knowledge, make sure that information is accurate. And the prospective buyer, if they said that they did work on the house, ask for a copy of their bill or their permit that they got from the city to do the work. The prospective buyer's real estate broker or salesperson also acknowledges receipt of this disclosure statement
Victor,
for the purpose of providing it to the prospective buyer. Yes.
yeah, we'll go to break now.
Yeah,
It's because I'm kind of hungry.
we're going to go to lunch in just a sec. Hold on. I'll just fill out this form here, or going over this form. So now here, both the buyer's agent and the seller's agent needs to fill this form out. Okay, and sign that rather. So that is the seller's property condition disclosure statement. And
What is the lunchtime?
okay, hold on one second. We're going to go to lunch. Listen, lunch is not always at 12 noon exactly on the dot. We have to.
I'm not in hurry. I'm just asking.
We're getting all these things. I usually have it at 12 or as close to 12 as possible. But if I'm explaining something, we're going to finish it
Right.
first, and then we'll
Okay.
Okay. But I usually keep it around 12, and then it's we get an hour lunch. So on that note, I'm going to pause this record. Okay, so continuing here with our fiduciary duties. So the duty of care requires the seller's agent to, among other things, be knowledgeable about all aspects of the property to arrive at a reasonable listing price. And I said we do that by doing something called a CMA. It's a comparative pricing analysis. It's similar to an appraisal, but should never be considered one because we're not licensed appraisers. So we can't do appraisals. So don't ever call it that. We can only do the CMAs for the public. So we do that for sellers to help them price their homes, and we do that for buyers to help them make a reasonable offer on a property. We don't just automatically ask them if they're going to make a full price offer. We got to price the property properly first. And we have to discover and investigate material facts. We discussed this. You could walk around the house and look around, and you could observe any issues possibly about the property, but material facts are not problems. Material information could be how many bedrooms and how many bathrooms as well. But we get all of this stuff by walking around, inspecting the homes ourselves, and having the seller fill out a seller property condition disclosure report, like we have here on the left-hand side. Now, examples of breach of duty of care could include failure to inform a seller about how property condition affects their value, or failure to effectively navigate the transaction through to the closing. A buyer's agent is expected to inform a client about whatever problems can be discovered through a reasonable investigation of the property. And you could do that by asking for the seller property condition disclosure report that they should have already filled out. You can actually visit the property. Don't ever put offers on a property without actually visiting it. And then advising them to get a home inspection. For your protection, get a home inspection, right? From a New Jersey licensed home inspector. Advise on probable market value by doing a CMA, just like we did for a seller, to help determine the value. Advise on financing options that may be available to them. Help negotiate the lowest possible purchase price, but not at the detriment of them not getting the property. Remember, the objective here is for the buyer to get the property. So don't go too crazy with that, trying to negotiate the lowest possible price. It's possible price, not ridiculous price. And monitor the progress of the purchase until the transfer of the title. A breach of duty of care might include failure to advise the buyer to closely consider issues that may be found in the seller's property condition disclosure, or improperly handling the escrow deposits. When the buyer gives you money as a deposit, you got to immediately give it to your broker. They make some entries in their escrow record book of who gave it to us, how much it is, when they gave it to us, what it's for, and then they go deposit it in the escrow bank account. And failing to obtain all necessary signatures on a contract, make sure you get all the buyers, all the sellers to sign. Otherwise, it's useless. And remember, I said, check their IDs. I gave you that advice. Always check IDs for the buyers, for the sellers. Always check IDs. At an open house even. Somebody walks into an open house, ask them for their ID. Don't allow them just to sign in. Check their IDs. And that's your opportunity to seem more professional to them. And it's not just seeming professional, it is being more professional. Because what agent asks for IDs at an open house, right? When have you ever heard that? Probably never, right? So by you explaining that, hey, the seller hired me, really? No other agents ask you for an ID? The seller asked me to look out for their interest. I'm opening the house to the public here. We got to make sure that name matches who you say you are, that you on a sign-in sheet. So I need to check your IDs. It's just being diligent. I don't know how an agent can possibly do that without checking your ID. If something goes missing from this house, we need to turn over this sign-in sheet to the police, right? So they could file a report. Jewelry goes missing, medications, money, something goes missing, check IDs. And the court sets different standards of care for brokers than they do for salespersons. The reason being is, to get a broker's license, you have to be in the business a lot longer. You have to go back and take a broker's course, take another exam. The more experience, the more education that you have on the job, the courts will hold you to a higher standard of care that you're supposed to provide for your clients. Okay? So every day you guys are here attending this licensing class. You're learning more and more information. So you're going to have more information out the gate than most people do, the average people do there in the general public. So courts will require you, though, to provide a higher standard of care than through the normal public. Now, any special classes that you get for special designations or training, courts will hold you to a higher standard of care of that as well. Okay, so here's a scenario. This is on the next page, 32. Here's a scenario that they often give a state exam question on, based on this type of a scenario, where you get a rookie residential agent. A rookie is a new agent. They get the opportunity to list a shopping center for sale. Do you know the first thing about selling a shopping center? Probably not. So an inexperienced agent should probably see if there's another agent within their own brokerage firm there. Check with your broker that may be has experience in selling shopping centers, and you could partner up with them for this transaction. And if you ever get another opportunity to sell a shopping center, now that you have the experience under your belt, maybe you could do it on your own next time. But it's a good idea to do this. Real estate's not a career where you fake it till you make it. Yeah, you're opening yourself up to lawsuits if you do that. So it's a good idea to try to partner up with another agent and both work to sell that property. And that could also be a learning experience for you. All right. All right. Let's take a slow. Have I been mute that whole time?
Just last 2 minutes, just 1 minute.
Wow, talk to me. Say something. Say something. Don't wave your hand. I just noticed you. I just noticed you there.
No, I said I did like this.
Mute yourself. Say something to me, guys. Oh my God! I don't know what you didn't hear. Did you not hear anything since we came back from lunch?
You said you heard the last time we finished it. You was going to the slideshow.
Oh,
You're good.
Mm-hmm.
You can hear me, right? Victor, can you hear me?
I can hear you.
Yes.
I can hear you. I didn't hear you saying anything. No, I just saw you waving like this, and I'm like,
No, I said, Victor, I can hear you. I can hear you. Like that.
all right.
Okay.
Yeah, I didn't hear a thing. So I
That's
just
okay.
happened to look over and I saw you.
Oh.
Yeah. And then I looked at my controls and I was like, oh shit. My audio was muted. Okay. So what I was talking about then.
We finished the example about the rookie, and then he was going to a slideshow.
The residential agent thing.
Yes.
Okay.
This is done.
Explaining this slide then. Okay. So.
Yeah,
so
this one.
You was
We
about to
done.
go to the slide.
You're seeing the slides, right?
No.
Yeah, this one.
Yeah, we seen this. You was going on the YouTube slide. We finished this page.
Okay.
The YouTube. Yeah.
Okay. So, right. So what I did is I moved the Zoom control out of the way and I hit the mute button because I got to grab the controls to push it out of the way. And I didn't notice that it actually changed it to mute. Okay. All right, good. Okay, so you didn't miss anything then. Okay, good. Okay, so once again, I got to move the Zoom controls. Okay. The red bars through the microphone. We're good. And
Okay.
anytime I play a video, I got to change this up to optimize it so that you guys can hear the audio better without less bandwidth, without it skipping perhaps, and you could hear it because you're funneling the audio directly to you instead of through my speakers and the microphone. All right, so we're going to take a little pause here for learning about the rest of the fiduciary duties. And by watching this slide here, it brings up a little discussion too. But we just went over the fiduciary duty of care. We're going to go over the rest of those fiduciary duties. We went care, obedience, accounting, loyalty, and disclosure. We still have to go over. But in the meantime, let's take a look at this slide. Of these New Jersey real estate agents, you tell me if they're doing something wrong here. You got two agents, both of them work for different brokerages. One is a listing agent and one is not. Let me just jack up the volume a little bit.
There's new video tonight of a pair of real estate agents accused of using a client's home to hide a steamy affair.
Ooh, steamy affair.
Well, now the tables are turning in a counter lawsuit. The realtors claim the video was part of an extortion plot. CBS 2's Hazel Sanchez has more.
The proof is in the pictures. Newly released surveillance video obtained by Inside Edition reveals veteran real estate agent Robert Lindsay locking lips with fellow agent Jean Marie Phelan in the foyer of a home Lindsay was hired to sell. The homeowners Richard and Sandra Weiner are suing Lindsay, along with Phelan and Coldwell Banker Real Estate, for allegedly using their Wayne, New Jersey home as their play pad to have sexual relations while the couple was at work. The owners say a surveillance system captured the agents making repeated afternoon visits to the home. Video from inside the master bedroom shows Lindsay and Phelan getting dressed after an alleged lovemaking session inside the Weiners' home. The Weiners say Lindsay intentionally listed the house at above market value so that there would be little traffic in the home. This still picture from one surveillance camera shows when Lindsay and Phelan realized their acts were caught on video. Now realtor Robert Lindsay is countersuing the Weiners, claiming they attempted to extort money from him in exchange for not releasing the telling surveillance tapes. Robert Lindsay alleges the Weiners asked for $990,000 in exchange for keeping the surveillance tape secret. The Weiners could not be reached for comment this afternoon. Christine?
All right, Hazel, thank you.
So,
Wow.
yeah. I mean, you don't want your story being all over the air like that, do you? So don't do stuff like that. Boom. There's the best way to avoid it. You know, because you got a listing agent and you got access to keys, or you're even a buyer's agent and you have access to keys and that are in lock boxes and such. That doesn't give you, that doesn't mean that you could use that house how you see fit. You know, they're using it as their private hotel room, you know. Now, as far as those accusations go, could that homeowner have been extorting them? Probably. I'd say it's more than likely. Now, those real estate agents, they got caught dead to rights, you know. But either way, let's focus in on what they did. Did either one of them violate a fiduciary duty to their client?
They both were agent, right?
Yes.
For buyer and seller, right?
Only the guy, Robert Lindsay, he was the listing agent. And the other lady, she was a real estate agent with a different brokerage firm. And the claim there was that they violated fiduciary duties, right? So what happened as a
There's new video to
what happened as a result of this? Well, I went to the disciplinary actions page on the Real Estate Commission's website because I was curious, as I'm sure many of you are. What happened, right? Can't just introduce some drama and not tell you what happened, right? So, yeah, I looked it up. Now, this is, once again, this is not to pick on anybody. I'm not picking on these people. We may come across them in working in the industry, but let's take a look. This is just for learning lesson here. I found this at the I found this video dealing with New Jersey stuff and for real estate, and then I looked it up on the disciplinary actions page, and now I use this as one of the examples of teaching lessons. This is how I get these teaching lessons here. So on the Real Estate Commission's disciplinary actions page, that's where I looked up, and you could find out more information about this case. And then I went to the Real Estate Commission's website for their licensing database, and I used these links, these resources, to find out if they're still actively licensed. Want to check? Want to find out?
Mm-hmm.
Okay, I already did this search using these links. By the way, all these links here take you to the same place. NJ Real Estate License Search and njreclicense.com and this tiny URL. These are 3 links that I made up. I bought these domain names. They point to this top one. This is the Real Estate Commission's website. But they have dashes and underscore, lowercase letters and uppercase letters, and it is case sensitive. So that's why I bought these. It's easier to just navigate there. And all these links, by the way, are in that class links Word document. Now, so here's what happened. Here's the links to the actual stories of what happened here in 2014. This happened. And I took these screenshots from the Real Estate Commission's website, but you could dive into it further by going into the consent orders and reading the actual court hearing of what actually went down. Yeah, more juiciness, right? So let's see. Let's start with Jean Marie Phelan, the woman. What happened to her? Well, she was a real estate salesperson in Passaic County, and they got her, they said that she violated NJAC 11:5. What is that? Well, NJAC, that's the administrative code. 11:5. Anytime we see anything that starts with 11:5, we pronounce that as Title 11, Chapter.
Real estate.
And so she violated this section of the administrative code, which is basically the rules and regulations of the Real Estate Commission. And anytime we see NJSA, that's New Jersey statutes. That's the laws that were created by the politicians. And it always starts with Title 45, Chapter 15. So she failed to protect and promote the interest of the property owners. Wait, but she didn't work for the property owners. We're going to discuss that in a second. And that the aforementioned demonstrated unworthiness. So her license was suspended for 6 months, and she has to complete a 30-hour broker course on agency and ethics prior to getting her license back, and she had to pay a $5,000 fine. Now, she didn't work for the seller, so why did she get in trouble? They say that she failed to protect the interest and property of the owners. Well, it's just like you. If you were a buyer's agent and you get access to the lock boxes that got the keys to a house, okay, and you open up that lockbox, get the keys to go in so that you could show that house. They put up a sign, please take off your shoes when showing the home and turn off all lights. You know, you don't just leave the house unlocked after you're done showing the property. You know, you don't drag mud through the house. You don't leave all the lights on and the doors unlocked. If there was an alarm code, you rearm the alarm. You don't just leave it unarmed. You leave that house the way that you found it to protect the interest and property of the property owners. Even though you don't work for them, you're getting access to their home. You have to safeguard their property. You have to treat everybody fairly and honestly and treat that house as if it was your own. Okay. There's some older cases here where, remember that show New Jersey Housewives, or Housewives of New Jersey or something like that? They got that whole series now all over the country. Housewives of Atlanta, Housewives of this place, of that place. Well, it started with the Housewives of New Jersey. You know that they actually started, when they did that in New Jersey, there was actually a disciplinary actions note on the Real Estate Commission's page, because a real estate agent went to show a house, and the lady loved the house, and they decided that they were going to use this house to film one of the episodes of Housewives of New Jersey, where one of them was going to be getting married or something. So they went into this home using the lockbox, and all day they kept other people from coming into the house while they used it for filming one of the episodes.
Oh my!
Without even getting the owner's permission. That's ridiculous. So the real estate agent got in trouble. The broker got in trouble for her actions as well, because you're not supposed to be doing stuff like this with an owner's home, especially without their permission. One was like really off the charts, though. Filming a TV show in somebody's house. All right, now this one, let's see what happened to Robert Lindsay. He was a real estate broker salesperson, so he had a broker salesperson's license. And he violated the same statutes, and he failed to protect and promote the interest of the property owners. He demonstrated unworthiness, bad faith, dishonesty. They revoked his license. That means that's the most severe. They could take away your license. So they took away his license for 1 year. How come they didn't just suspend it? You can't work when your license is suspended. Why did they revoke it? Well, because you have additional powers that the Real Estate Commission can do if they revoke a license. So they temporarily revoked his license for 1 year. And in order to get his license back, he had to complete a 30-hour broker course on agency and ethics law, as required prior to getting his real estate license back. And should he wish to obtain a New Jersey broker's license following the suspension, he's required to requalify by retaking the entire 150-hour pre-licensing broker course and passing the state exam again. And he got a $10,000 fine. So what was the difference there between getting your license suspended and revoked? Well, suspension, when you get your license back, you get it back the way that you had it. When they revoke your license, they can knock you down a block. And that's what they did with him. He had a broker's license. Now, when after the 1-year suspension, he can come back and get a salesperson license. So if he wants to get a broker's license, so they took away his broker's license and gave him the lesser salesperson license. So, those broker classes back then, they were about $1,200, $1,200 too. So he's got to pay $1,200, take the broker's course, a 150-hour course, which takes several months, and then take and pass a state exam again. And he got a $10,000 fine. So, did they do it? Let's take a look. I did a search, and yes, they're both actively licensed. And it doesn't look like he went back to get his broker's license because he's actively licensed as a salesperson. All right, let's move on. This just shows you how you can look up if somebody's ever been found guilty of something, if anybody ever did something wrong, got fined, and all that. Okay, let's move on to the next fiduciary duty of obedience. You're not a dog, but you must obey your client's lawful instructions. Like if they tell you, hey, no showings without a 24-hour prior notice. Well, set up an appointment for 24 hours. And don't tell the person, oh, I'll contact the owner and see if I can show it in an hour. All right. They give you instructions, no showings without a 24-hour notice. Don't go calling them up now. I got a call from an agent. They want to show it in an hour. So what? We told you no showings without 24-hour notice. Let them know they could schedule a showing in 24 hours. No showings unless the buyer's produced a mortgage pre-approval letter first. Okay, is that going to prevent a lot of people from possibly showing the property? Yes. The reason being, a lot of people start the home search process by getting a mortgage pre-qualification letter. You guys know the difference between a mortgage pre-qualification letter and a pre-approval letter?
No, I don't.
Okay, then let me explain. All right, let me grab a folder here. I just got any blank pieces of paper here. Okay, let's just say that this piece of paper is a mortgage pre-qualification letter. What is required to get this pre-qualification letter from a lender? Well, the buyer needs to call up a mortgage solicitor, mortgage rep, lender, and they provide their name, address, all that stuff. They provide their social security number so that they could do a credit check, and then they verbally tell them how much money they make and what their approximate long-term debts are. And based on that information, the mortgage rep does some calculations, and then they say, okay, well, we determined that you are pre-qualified to get a loan up to this amount with this kind of a down payment and this interest rate. And so they print it out. Now, so far, nothing's been verified except for the credit history, the credit report. So you don't know if this person can actually get a loan or not. But that's what most people go out starting their home search with, is a mortgage pre-qualification letter. So what's the difference between that and a pre-approval letter, which is much better? Well, the pre-approval letter, they do the same stuff. They get on the phone with the mortgage rep. They give them their social security number so that they could run their credit. And then they not only tell them how much money they make and what their approximate long-term debts are, they provide their bank statements, their pay stubs, and their tax returns. So all the information now gets verified by the underwriter at the bank. And once all that information has been verified, they calculated the risk and determined whether they're going to grant the loan or not. Then they issue a mortgage pre-approval letter. So now you're approved, provided that nothing changes by the time you find a house, nothing changes in your employment or your income or debt situation, provided that nothing changes there, you are approved to get this loan. But there's a big asterisk next to that approval there, provided that the house appraises for the purchase price and it's below a certain value and the taxes aren't above a certain value and dot, 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 dot. So that's the difference between a pre-qualification and a pre-approval letter, is that the pre-approval letter, all the information's been verified. Pre-qualification letter, it has not. So you can't even tell for sure if that person's even going to be able to get the loan. With a pre-approval letter, you know without a doubt that they could get the loan. Okay, so which one's better, pre-approval, pre-qualification?
Pre-approval.
Approval.
See, every day you're learning something else, and it's making you have more knowledge than the average person there in the general public. So I tell people, start off, get that pre-qualification letter before I even start my computer to do the home search for you. And then work towards getting the pre-approval letter by supplying all the information to the lender. So this way, when we find that perfect home for you, if we get into a situation where there's multiple offers, I have some more ammunition to negotiate. I could show that the buyer that I'm working with has been approved for a loan. You know that they could get the loan.
Mhm.
So Mr. and Mrs. Seller, if you have any other offers on this property, are they accompanied by a pre-qualification letter or a pre-approval letter? Pre-qualification letter, you don't know if they could even qualify for that loan yet. See, we already went through the underwriting process. Those other people, it's a big question mark. So something like this will allow me to be able to negotiate in a way that even if my client's offer is less, I just elevated it to the gold standard because you know they could get the money to buy it. The other one, you don't know, right? So the way I usually start off that conversation, though, is I like to present the offer, and I bring a copy of the offer with me. And if we're doing it in person, if we're doing it on phone, I just have them in front of me and I'm explaining it to them. And I tell them, I'm sure your real estate agent had already explained to you at the time you got this listing what the difference is between a mortgage pre-approval and a mortgage pre-qualification letter. Well, just in case they didn't, let me re-educate you on this. So and then I get into the whole spiel and I explain that a pre-approval letter is better than a pre-qual. And then from there, then I start moving into, well, this offer, this is the price, this is the terms, these are the conditions, and this offer is accompanied by a mortgage pre-approval letter. You know they could get the loan and complete this transaction, provided that your house appraises for the purchase price and there's no major issues with the house. Okay?
Mhm.
And so now I just elevated my client's offer to the gold standard. So now every other offer, and if there is another offer on the table, what do you think they're asking their agent about it? Does it have a pre-approval or pre-qualification letter?
Mm.
Pre-approval.
So that means that they're just at the top of the list.
They ready to buy.
You're going to take your house off the market to accept one that you don't even know if the person can qualify for the loan? Or if there's a multiple offer situation, which one would you take? The one that offers more money, but you don't know if they could actually get the loan? Or the one that may be a little bit less, but you know they got a solid approval already in place that they can go through with the transaction?
The solid approval.
Yeah. Yeah. Okay. So, the agent, that's you guys, must advertise the property at the agreed upon asking price and not encourage any offers any less. So you prepared that CMA, that comparative market analysis, to help the seller determine how much their home is worth. That's a whole process all in its own going through that presentation. But anyway, we established the price that they want to list it for sale at. You don't go encouraging anybody to make an offer, even if it's a lesser offer. You always try to encourage them to make the highest and best offer. Okay. Don't encourage them to make an offer less, even if you were told by the seller that you know that they will accept a lower price. Don't go encouraging that. And definitely don't go advertising it in other websites that, at a lower price than agreed upon. Otherwise, you're violating your fiduciary duty of obedience. Now, an agent must disobey any unlawful instructions. So if a seller tells that agent not to disclose known issues or problems with the house, we can't do that because we're representing the seller, but that doesn't mean we could try to screw over any potential buyers. We need to treat the public fairly and honestly, even if we're not representing them. So we can't lie to them or misrepresent facts.
So how do you do that?
So even if a seller tells us, don't tell them about the leaky pipe, I have to tell them about the leaky pipe. As a matter of fact, even if you don't hire me, you have to tell them about the leaky pipe because you have knowledge about it. Otherwise, they could sue you and they could get triple the damages from that lawsuit if you fail to disclose it to them or you lied to them about it. That's why we fill out a seller's property condition disclosure report and disclose all the information that you know about the property, even things that may not be readily apparent that may be issues with the property. And then it's up to the buyer to decide what they want to do. Okay. They can make an offer and ask the seller fix it. The seller can say no, and then you need to make a decision. Do you want to go through with the purchase and then still fix that? Or do you want to walk away and go to a different property? It's up to you. But you need to have, everybody needs to start off at a fair playing field, knowing what is the condition of this property. If the seller knows there's issues, they need to disclose them. Okay. So the job as real estate agents, we're required to investigate and disclose all material information as well as material defects in a property. So if they tell us to show the property to a certain protected class of people, say, hey, don't show it to these people or those people because of their religion or their color or their sexual orientation or whatever the protected class is, okay? We can't do that. Actually, if we're going to get a listing and somebody tells us that they plan to discriminate, we have to turn down the listing and walk away. We're not allowed to take the listing. This is an exam question is going to be based off of this scenario too. And one of the answer options that they give is, well, explain to them that discrimination is wrong. And then if they agree to it and they see the light and, then take the listing. As long as you have that discussion with them first and they agree. That's one option. Another option would be to walk away or turn down the listing. And then they give other option scenarios. Okay, so what should you do if somebody tells you that they have an intent to discriminate when you're going in to get a listing? Walk away. Because look, you can explain to people discrimination is wrong, and then they could be like, okay, yeah, but they could be yesing you to death, and they still are going to discriminate. And if that happens, now you're opening your brokerage up to lawsuits too. So obedience, the agent has to obey the lawful instructions. The agent, however, is not required to obey any unlawful or unethical instructions. For example, violating fair housing laws or misrepresenting a property's condition, or on a buyer's side, misrepresenting the buyer's finances, whether they could actually qualify and get the loan or not. So that's still considered material information that the seller would want to know. Now, the agent must obey all the client's lawful instructions. I already went over all this stuff in the previous slide, so this is just where it says it in the book. Okay. Accounting, that's also on page 32. Accounting, that's another fiduciary duty. The agent's responsible for the money and or property of our clients, right? Your clients give you a deposit to make an offer on a property. What do? You immediately give it to the broker. Then the broker asks how long to put it in the escrow account.
ID.
All right. Keeping attendance records for agents showing appointments. Your office should be doing that. And then also at open houses, you're required to have a sign-in sheet. Remember, check the IDs for all visitors. Why? For security reasons, in case of theft, to get feedback, to solicit feedback for the owners, and to follow up and try to convert some of those looky-loos into buyers. Never let a licensed person access and never use a key lockbox to gain entry to a property without prior approval from the owner. I guess that also entails don't go letting a film crew in there to film an episode of Housewives of New Jersey, or don't be using that as your own private hotel room either. You know. All right. So let me click on this link because this is a link on the New Jersey Real Estate Commission's website. So let's click on it for a second and let's go there. It is important enough for them to make a post about it, so we might as well read it. The use of lockboxes on properties to be sold and leased is common practice to facilitate the sale or lease of property, and it's regulated by the requirements of the MLS services available within the state. For general information on the placement of lockboxes, hey, listen, you put them on either the railing, if it's a metal railing, or you secure them to the door handle. Don't go attaching them to tree branches. Somebody can snap a tree branch, steal it, take a sledgehammer to it and try to force it open and smash it open, get the key out of it and come back and rob the house later. So don't go putting them on tree branches. In any event, the safety and security of both real estate professionals and the clients they serve is the utmost importance. This extends not only to individuals involved in the sale and purchase of the property, but to the premises listed for sale or rent. It's come to the attention of the commission that some licensees are not taking the necessary precautions to ensure that those clients' interests in the purchase or lease of a home are being accompanied while viewing a property. In addition, properties are also being left unlocked or not properly secured after access. Regardless of the reason, whether it's a home inspection or to go there to take room measurements, showing additional family members the home, no one should be allowed entry to the property without prior supervision, without proper supervision, and under no circumstances should unaccompanied access be granted without the seller's full knowledge and consent. And failure to do so may subject the agent to sanctions in violation of their administrative code. So basically, you could be fined or even have issues with your license if you don't get the owner's permission. First of all, to show, you got to set up an appointment. You know, I showed this the other day to the other people in class. I'm going to show it to you guys right now. This is called a Supra lockbox. It comes from a company called GE Security, you know, like General Electric. It's called Supra. This is a steel lockbox that's covered in a type of rubber that will try to prevent the door from getting marred or scuffed up. So you put this on the door handle, you know. Now this part, they call that the shackle. The shackle can come off and then it locks into place, and it's made of steel as well. So there's a lifetime battery that's inside of this thing. The battery is not active right now. The way you can tell it's active is there will be a light flashing here. And the way that you make it active is you push up on the bottom. You see that? Now it's flashing. That'll do that for maybe about 30 seconds or so. So you have that time to get your cell phone out, open up your lockbox application, which you're going to be paying a fee for, a service for. You're going to hit the key, the picture of a key that's on there. You're going to put in your secret security code that only you have. And then the lockbox drops out from the bottom. And it has the keys. That's where you put the keys inside of there.
Oh, wow.
Okay? And then after you're done showing the house, you put the keys back in. Put that back in and it locks back into place. All right. So that's how these work. And the shackle works in the same way. Here, let me enter my shackle code for here. I got it written on the back of this particular lockbox on a piece of paper. So let me enter mine in here. Make sure it's active. So now I could pull it off. See that?
Yeah.
So this has got, you can see the hooks under there. You got little hooks at the edges of this thing.
Yes.
Mhm.
All right. So those hooks, well, then you put this around a door, or you put it around a metal railing, perhaps, and then you.
So
It's
there
locked.
are two ways to open it, right?
No, that's for the listing agent that's putting the lockbox on the property. All that does is for the shackle code. Now, all agents that have access to the Supra box can open up a Supra box, the bottom where the keys are. And it keeps track of it. The software keeps track and sends a notification to the listing agent that their lockbox was just opened by you. And when. So it keeps time, and you can even set timed access, certain days and certain times that it can be open. So it can be limited.
Mhm.
Okay.
So there's a little lesson about how lockboxes work. But anyway, you don't ever give anybody the access. You don't open up giving them keys to a property, let them go see it on their own, or open up the property for them and then leave them there alone. All right. So when it comes to accounting in the book, they say the same thing that I had on the previous slide. We got to look out for the money and or property of others, right? So we got to put that money in the escrow account for within 5 days. But how long does the broker need to keep copies of those escrow records? You know what? I'm actually going to add that here, even though we've already gone over it, but we're going to go over it again somewhere else too. Let me find this slide.
What's the question? How long? How long?
Yeah, how long does the broker need to keep copies of all records?
6 years.
Oh,
6 years.
oh, okay.
6 years, except for two things: unaccepted offers and expired listings. Those
Okay.
things only need to keep for 6 months. So money must be placed in the escrow account within 5 days. And the broker is required to keep escrow records for 6 years. There we go. I updated that slide. You know, I'm also going to take that little note there, and I'm also going to add it to that Word document that has all these notes that you see on the slides that I keep updating for you guys that you could use as your own study notes, which here I'll also show them to you, right? See, I've been updating them with some of the slides, some of the images, but also all the wording, so you guys can read the wording. All these slideshows are all in one document, the Word document. You also have access to the slideshows too, but these are good study notes for you. So what was I updating? Okay, so accounting slide sheet. Okay, so here we go. This is what I was doing. There we go. Just adding that bit to there, save it, and there you go. That's what we just went over, right? So back to the slideshow. All right. Loyalty. That also includes confidentiality. You must be loyal to your client's interests. Anything they tell you in confidence, you must keep your mouth shut about. If you can't keep a secret, don't ever represent anybody as an agent, because you're opening yourself up to lawsuits. So loyalty includes confidentiality. If the seller, for example, told you that they're willing to accept a price lower than the asking price, You don't go encouraging buyers to make an offer and, hey, as long as you keep it above this amount, you're good to go. What are you doing? You have to encourage people to make the highest offer possible if you're representing the seller. So you make your highest and best offer, put it in writing. That's what you tell them. So the agent must not disclose any information a client shared with them in confidence, like they're willing to accept a lower price, or if they're a buyer making an offer and this offer doesn't accept it, they're willing to make a higher offer. I've seen agents try to rush the process, where what they do is they make an offer on a property and they're so excited about, and they know there's an urgency because there's other buyers out there that may step forward and make offers too, but you're the first to the table. So they want to make sure your offer gets accepted. I actually had an agent do this recently too. They said, hey, listen, this is our offer. We're making this offer, but if it's not accepted, let us know right away so that we're able to make a higher offer. We just want to make sure we get the property. I'm thinking to myself, hand over the face. Oh my God, dude, what are you doing? You just violated your fiduciary duty to your buyer, to the buyer you're representing, because you just told the seller's agent, hey, listen, we're making an offer on this property. It's lower offer than the asking price, but if the seller doesn't accept it, we're going to make another offer that's higher. You just violated your fiduciary duties. Now, who in their right mind would accept that offer? So, but I have a fiduciary duty to now go back and notify the seller. I have to forward all offers within 24 hours. So I either go to the seller or I call them on the phone and I say, hey, listen, an offer just came in on your property. And I had an interesting discussion with the seller's agent or the buyer's agent. They told me this is the offer and this is all the details of the offer. And they told me that if you did not accept it, that their client was ready to make a higher offer. So what do you want to do? What do you think they're going to do? So I cannot keep that information to myself, though. I have a fiduciary duty of disclosure, notice. I have to go back and notify my client that the agent told me this information. See, disclosure or notice is any information the agent gains knowledge about. They must be reported back to their client, and they can decide what they want to do with that information. I can't keep it to myself. I know that agent screwed up, but that's not my problem. I got to represent my client's interest. So I have a fiduciary duty of disclosure to go back and disclose that information to notify my client of the information that I had just learned. Now, that other agent, they violated their fiduciary duty of loyalty. They didn't keep that information in confidence. They tried to rush the process. I know why they did it, but that's not how you play this game. You got to make the offer and wait to see if it gets accepted. If it doesn't get accepted, then you could bring forward another offer. You don't tell the other side what your whole entire game plan is. That's not how negotiations works. That's not too smart of a thing to do. So here's some more examples of loyalty or confidentiality. If a seller needs to sell quickly, or to accept a lower price, or to pay more, if the buyer is willing to pay more, licensees must disclose any personal interest the agent has in the transaction, including relationship with the parties to the transaction. Like if you're helping your mother buy or sell a home, you have to disclose that in the contract, that you're a real estate agent with ABC Realty and the client is your mother. Okay. If you're Scouts and you're helping that organization find a new campsite, you have to disclose your relationship. You got to say, hey, listen, on the contract, you got to disclose that the client is the Boy Scouts of America and they're looking for a new campsite. And I am a real estate agent with ABC Realty, and I am also a member of the Boy Scouts. Okay, so you got to disclose that relationship. Are you jeopardizing anybody's negotiation stance by disclosing that? No. And you're required by law to anyway, so disclose it. Or if you're buying the property for yourself as an investment, you got to disclose that on a contract. I am the purchaser. I am also a licensed real estate broker with ABC Realty, purchasing this property as an investment for myself. Boom. That's it. All right. So let's go over some more of the breach of fiduciary duty of loyalty. Brokers or salespeople may not buy property listed with them for themselves or for accounts in which they have a personal interest without first notifying the principal of such interest. You guys should probably underline those words or highlight them there on page 33. Can you buy a property that you have listed? Yes, you can. As long as you first disclose those interests to the principal, your client there. Neither broker nor the salesperson may sell property in which they have a personal interest without informing the purchaser of that interest. Such a disclosure must be made in writing as part of the purchase contract. And then at the bottom of page 33, that's where we see the breach of duty. Oh, wait, no, that's not 33. Loyalty, confidentiality, breach of duty of loyalty. Okay, this is on page 34 here. This part, breach of duty of loyalty.
Oh, we have to write it down. First two sentences of paragraph below omits from 18 version book. That we have to write it down, right?
Well, take a screenshot of the newer version book. Wait, let me see. Yeah, I didn't take a screenshot from the newer version book to put in here because this one, under breach of duty of loyalty, this is page 33. Breach of duty of loyalty. Here, it was reformatted a little bit in the newer version of the book. Wait, did I put the new version here? No, I didn't. Okay, so you guys could follow along. I want to read what I have on screen. You guys could read in the book there under breach of duty of loyalty, the first paragraph, and see what the difference is. Agents may not advance their interest at the expense of the principals. Any attempt to profit from such transaction, except through the agreed upon commission, signals a situation in which their loyalty may be breached. Agents may not advance their interest at the expense of the principals. Any attempt to profit from a transaction, except through the agreed upon commission, signals a situation in which loyalty may be breached. Okay, so it has a little more information than this version of the book has. I don't know why they dropped some of those sentences. Everything else is the same. So you should underline here, profiting from a client's misfortune is forbidden.
Excuse me. So the book that we have up to loyalty might be breach. That's it.
You have up to here, right?
Yeah.
Agents may not advance their interest at the expense of the principals. Any attempt to profit from a transaction except through the agreed upon commission signals a situation where the loyalty may be breached. So I don't know. I don't know why they removed that from this version of the book.
Oh, I see. So which one? The book that we have, that's a recent one, right? That's a new one, right? Updated one.
Recent version, but in this version of the book, they did omit a lot of things that were in previous versions, and here's just one example of that sentence. So I'm just making a note for myself since I'm helping with the rewrite of.
Right.
Okay.
First two sentences, paragraph below, omitted from 18 version book. First two sentences.
You said the first two sentences are the same or they're different?
Yeah,
Agents.
first two are same. The rest
Okay.
of them we don't have it. Yeah.
Okay, so the last two sentences of the first paragraph are different. Okay.
So first two lines are we have it. Then from agent may not advance, we don't have it.
Two sentences a paragraph.
Last two sentences, right?
The first paragraph below omitted from 18th version. Okay.
Right.
All right. But you get the gist of it either way, even just not having all that wording in there. You don't have to write all this in there. But you get the gist of it. You're paying attention now. You have to disclose, because the only way you could make money off of your clients is whatever's been disclosed. It's like the deposit money that a bank gives you. If you put it into a escrow account that's interest bearing, you don't get to keep that interest. The broker doesn't get to keep that interest. They got to pay it to their clients if it's put in an interest bearing account. All right.
So excuse me, you are updating the notes. So right now it's open, but later on when I reopen, it's gonna be updated one, right?
Oh, this is yeah. See the words that I just the rewording. Yeah. Yes. Correct.
Yeah.
Right. Okay. Now, but I need to study this word for word. As long as you got the explanation, you understand the concept.
Yeah.
You can't be making a secret profit on your client's money. Boom. That says it all right there. Okay. This is just a little long-winded way of explaining all the details. You can't make a secret profit off your clients.
No.
Okay. And also profiting from a client's misfortune is forbidden. So another example of breach of duty or loyalty of an agent who subtly discourages offers by co-brokers in the MLS system in hopes of securing a sale from within their office themselves so that they can get both ends of the transaction. So basically you get an outside agency trying to call up and set up an appointment to show your listing. And you're like, the property needs a lot of work, this is wrong with it, that's wrong with it, that's wrong. And you really make it sound like a crap hole that you really probably wouldn't want to show, to try to dissuade people from wanting to make an offer so that you could get your own client in. Some agents even do it in a way where they don't even say anything to someone. What they'll do is they won't put any good pictures or any pictures in a listing in an MLS. Sometimes they don't put any pictures, or I had this one once. An agent put in the picture of the back of the house. Why put a picture of the back of the house and not the front of the house? It's like they're trying, and that was the only picture. They're not. It's like they're trying not to encourage anybody to come and show the house. All right, so disclosure was closely tied to loyalty in the previous one, right? As you can see, the one agent didn't keep confidential. They weren't loyal to their client's interest. They let it slip out in their excitement of trying to get the offer accepted. But that's not my problem. As a listing agent, I had a fiduciary duty of disclosure to go back and notify my client about that information. So any information told the agent, the law considers that the client's been notified. So basically, if I find out something, if I'm your agent and I find out something, whether I tell you about it or not, in the eyes of the law, you've been notified. Reason being is, as your agent, I have a legal obligation to go back and notify you about that information. So in the eyes of the law, you've been notified. And if your agent violated their fiduciary duties, well, go after your agent. But they had that knowledge, and they're a representative of yours. So that's your problem. Okay, so any information told the agent, the law considers the client has been notified, whether it's discovery of problems or the other party's willing to pay more or accept less. Remember, when you act as a dual agent, you will always have this kind of knowledge handy. Because one party told you something, but you're representing both parties. You cannot place one party, you can't play favorites. You can't put one party's interest above another. Okay? All right. So in that regard, you don't have the full loyalty to your clients when you're acting as a dual agent. But then again, if somebody lets you work as a dual agent, are they losing out somehow? No. Reason being is no agent should be disclosing and violating their fiduciary duties of their to their clients. So most agents do not do such things. So it is rare that it actually does occur. But when it does, I have a fiduciary duty to go and report that information and notify my clients about it. So if I'm working as a dual agent, you lose out on that because I have knowledge from one party, but I can't go back and report it to you. So some people are like, oh, I would never work with an agent as a dual agent because then they can't go back and report things to me. Well, in most situations, do agents gain knowledge? Are most agents violating their fiduciary duties to their clients and they're gaining knowledge that they have to go back and report to you? No. So it shouldn't be a thing anyway. All right. And so here's just in the book, disclosure of notice. That explains all that same stuff. Now, in certain circumstances, the broker can be held liable. Yeah. In certain circumstances, the broker can be held liable for damages for failure to disclose any information that they learn about. The fiduciary duty owed by a buyer's agent to the buyer's principal includes conveying to the buyer any information that the seller is willing to accept a lower price. Or it's all the same stuff I just spoke about. All right. But breach of duty of disclosure of notice, the law considers that any notice given the agent has been given to the principal, and the agent therefore has a duty to pass on material information. All written offers must be presented immediately within 24 hours.
24 hours.
Right? Okay. Now we're going to have a couple slides. We just went over all of the fiduciary duties. What are our fiduciary duties? We learned an acronym to memorize them. COLD, spelled C-O-A-L-D. Care. Go ahead, guys, finish it. Care.
Confidentiality. No, sorry.
Let's try to do it in order for C-O-A-L-D. Care.
Obedience. Accounting.
Accounting.
Liability.
Loyalty.
And
disclosure.
Disclosure. That's it. You see why I want you to keep repeating it until it gets stuck in your head? Care, obedience, accounting, loyalty.
Quality. Care, obedience, accounting.
Care, obedience, accounting.
Loyalty. Disclosure.
That's right. So if you keep repeating it over, you'll eventually stick in there. Okay. All right. So now we're going to watch a couple videos and see a couple things about realtor safety because I care about you guys. And this is a service industry. And just like any other service industry, like the pizza delivery guy, they could get robbed and mugged and stuff can happen. So we're going to go over some realtor safety videos. We're also going to go over issues like this one. This one is about using video and audio recording devices in a house. Homeowners may have security systems in their home. Okay, this video is just going to talk about the legalities of that.
Over the past week, we've reported in depth on the local housing market, and we found out about a real estate warning regarding home cameras.
Now, this doesn't just affect people who are buying or even selling a house. It could very well change how you protect your home. Our Michael Wooten talks with the experts tonight in this Two on Your Side original investigation.
Whether it's driving down the street, buying something in a store, or just walking through a neighborhood, so much of what we do is now captured on camera.
It's a whole new world.
Oh, there's no doubt about that. And somebody's listening always,
and somebody is watching always.
There are about 770 million surveillance cameras worldwide. By the end of next year, that will pass 1 billion. And a lot of the new ones are going inside homes, with this type of technology becoming more and more mainstream. That's prompted a relatively new warning for house hunters.
We're telling buyers, be cautious.
Because your reaction could be recorded. Local real estate agent Barry Chubb now advises his clients to keep quiet while perusing a property.
Don't show all of your emotions because you might
lose some leverage.
You might lose some leverage and they may see these guys want it.
A nationwide Harris poll commissioned for NerdWallet found among people who had sold a home, 15% said they used security cameras.
That's a pretty high number.
That is a high number, and I expect it to keep going up as home security cameras become more mainstream.
Not everyone uses the footage to spy on potential buyers, but some do.
Eavesdropping one.
And noted constitutional expert Paul Cambria says that raises serious legal questions.
For video, it all comes down to the expectation of privacy, meaning someone installing a camera in a living room would be very different than recording in a restroom.
I can video you without your consent as long as it's not a restroom or a changing room. And that's not a violation of the law.
But that's just for the video.
Audio is very different. Just like with a phone call, here in New York State, you can only secretly record someone if you're part of the conversation.
That also applies here in New Jersey. New Jersey is also one-party consent when it comes to that as well. Otherwise, we start getting into violating the law of illegal wiretapping. That falls into that realms of the law.
It's known as one-party consent.
Any way that you overhear someone's conversation without their knowledge in a private setting is against the law.
If you violate the law in terms of recording someone's audio, it's a serious crime.
It's a felony. It's a 4-year felony, felony, so it's a very serious thing.
If someone wants to not break the law and they're selling their house and they have these cameras, your advice to them would be turn the audio off?
Well, that's one of the ways. The other thing is you could put up a sign that said video and audio recording in progress, that there would be implied consent.
Keep in mind, this goes beyond just people buying and selling homes. If you own one of the popular Ring doorbell cameras, for instance, you could be violating the law and not even know it.
If someone comes up to your house and they might be on the phone with someone or having a conversation with someone else, if you're listening to that, and you don't have their permission to listen to it, it's a felony.
With that said, it is a difficult crime to catch and prove. So Barry stresses to buyers,
keep your poker face while you're viewing the property.
And sellers should remember, a lot of buyers will be turned off if they see they're being surveilled.
In our survey, 25% of buyers said that they would lose interest in buying the home if they found out that the seller was spying on them. So, seller beware.
Using technology to get an edge, but potentially breaking the law in the process.
So the Cliff's Notes version of this, typically video is legal unless it's in a bathroom or a changing room
like
or something.
You said, right.
Typically audio is going to be illegal unless you are party to the conversation or unless you make it very clear to someone, I'm recording this conversation.
Right.
So you make that clear by a sign or by telling them?
You can do a sign. You can tell them if you're selling your house, it's a good idea to tell your real estate agent to tell the buyer's agents,
Right.
I have cameras installed, put up the sign, or turn off the audio because audio really is the problem.
And a lot of these home security systems not only have video, but they have the audio included as well.
And the chances of someone getting arrested and charged with this is
Very
pretty slim.
faint.
Right.
Yes.
But you could be breaking the law.
You never
And
know.
as he said, it's a felony.
It's a
Serious stuff.
surprise because people think, hey, if it's happening in my home,
I can do what I want.
but you
So
can't.
don't show your emotions when you're looking at a home. Don't say, honey, I love this house. Let's buy it and overpay for it.
Keep it to yourself.
And
Keep it
don't
to
say,
yourself.
what awful decor either,
Yeah,
because
right.
the price might just skyrocket
That's
then.
right.
Interesting. Great
Thanks,
report.
Mike.
Thank you, guys.
Michael.
Interesting things that people may not, but the top of their head when going into an house or getting a showing from a real estate agent, or the real estate agents may not be even thinking about this stuff off the top of their head. So it's not a bad idea to put this into your listing packages when going to meet with homeowners when trying to list properties for sale. Let them know if they have security cameras inside the house and they're recording the audio as well as the video, that they need to put up a sign to disclose that so that while people are showing the houses, you're getting that implied consent that it's okay for you to do this because you notified them that you got audio and video recording taking place in that property. Having security signs outside saying that is a good thing as well, or anywhere inside the house, so that you could avoid that potential issue. All right, now we'll talk about your safety a little bit with a couple of these videos here about realtor safety. Just like any service industry, when you deal with the public is freaking crazy. There's a lot of weirdos out there, right? So let's try to stay safe out there. Always listen to your sixth sense, okay? If you feel like something is wrong, chances are there may be something wrong, okay? I'm just going to give you a couple of videos that go over this stuff.
You train for something like that and you pray that you never ever have to do it, and then you find yourself in that situation, and it's very.
Is the volume fine here? Can you guys hear this? Is this volume coming across good enough? You guys are hearing this?
Yes, we're hearing. Yes.
Yeah.
Real.
Well, she's grateful for that training and the quick response she got from Commerce City Police. A realtor sharing her frightening run-in with a man who pulled a knife on her during an open house.
9 News reporter Noel Brennan sat down with her this morning.
How strange it must feel sitting in this chair, sharing a story Donna Hetzler never expected to tell.
If I did not have my firearm, I would not be here today to talk to you.
Here inside the Commerce City Police Department, the realtor spoke about Sunday morning.
So I was setting up for an open house. I went into the place and turned on lights. And not too long after I got lights on, somebody knocked on the door.
A man who seemed interested in the place.
He was asking the right questions about how long it had been on the market. We talked about loans and what he might qualify for.
Nothing unusual, but he wanted to see the rooms upstairs.
We got into the master bedroom and he pulled a knife out. And I could not believe it was happening.
He showed the knife and a can of bear spray.
He asked me to take off my ring and to get in the closet.
Donna says she felt her life was in danger.
I have a license to conceal carry, and I had a firearm, and I drew my weapon. As I drew my firearm and he saw that I had that, he doused me with bear spray. So at that point, I could not see, barely see, and my skin was burning. My eyes were on fire, and so I fired.
Donna and police can't say if the man was hit, but he ran off and is still missing.
I want to believe the best in people. I don't want to think that there's terrible people out there that want to harm somebody. And so the initial thought was disbelief that this is not happening.
Donna was prepared for the day she trained for, but never expected.
I don't expect people coming to look at homes to have bad intentions, but you prepare for any situation.
So Commerce City Police, they're working to release a sketch of the suspect right now. He's just...
Yeah, they ain't gonna find that guy. All right. But just to show you, hey, the Second Amendment works, guys. Even though New Jersey is a very, very blue state, meaning they're like anti your rights to defend yourself. A lot of laws have changed recently in New Jersey that allows you. Makes it easier for you to get your carry permit if that's something you would like to do. Just make sure you get training on it, on how to use it, so that you don't hurt yourself or someone else unintentionally. But either way, it used to be very, very, very difficult in New Jersey because they left it up to the judges to decide whether they wanted to give you a gun or not, a permit to carry a gun by exercising your Second Amendment right. However, some of the extremists that are anti-gun, they tried overreaching in New York State, and they tried really going for the gusto to try to do put a death nail in the Second Amendment once and for all by putting in some massive restrictions. However, they lost the case up at the Supreme Court level, and when that happened, it kind of backfired on them. It actually opened it up and gave more rights for people to exercise their Second Amendment rights. So as a response, there's always the anti-gunners always have something to say. So what they did as a response to that is they tried putting rules into place about when you can carry, which then that gets disputed. Is that constitutional, telling you that you can't carry in certain areas? New Jersey ended up doing that as well as New York, and they're trying to add a list and make that list longer than Santa's list. You know, they wanna make it so that you can't bring it with you anywhere. But all this stuff is continually being fought. So you always, if you do decide that you want to get your carry permit, take the classes that are necessary for this and get the licensing and all, make sure you follow all the laws and rules and make sure you keep up on them, because they are ever changing, especially in the blue states like New Jersey, that apparently hate legal gun ownership. So it's a jungle out there. You got to defend yourselves, guys. If something should come up, and how you go about doing that, well, I'm going to leave that up to you. But I'm going to have a couple of videos here to give you some tips. You know.
Next tonight, closing the open house.
Hey Victor, can you just let me charge my phone for a little bit, because it's literally about to die, and I need to let it charge a little bit so I can come back to the meeting. Is that okay?
You can have it plugged in while you're in the meeting. Plug it in.
Huh?
You plug it in while you're in the meeting.
No, I'm just gonna be out for a little bit, just to like at least let it charge to 20, because it's about to die.
Okay. Well, I was just saying you could keep it plugged in while you got the.
Yes, but it's about to die.
All right.
That's why. It's
Okay.
like literally the thing, I cannot see it. The screen is all black.
All right. Okay, so continuing on here.
Real estate agents. One broker in Iowa received calls so threatening, her company pulled employees off the streets. ABC's Lindsay Davis reveals the big risk to agents who often work alone.
Realtors on high alert tonight after an agent in Des Moines received a terrifying threat.
There's no commission check that's worth putting yourself in a dangerous position.
Managers at this firm say someone called one of their agents from a blocked number. The caller telling her that her name was picked at random out of a hat as part of a gang initiation, reportedly telling the agent they intended to bring harm to her and that they'd see her later that day. After hanging up, that agent called police. Her company shut down all scheduled open houses and pulled their agents off the street. That call is being taken very seriously in light of recent events. Just last year, Arkansas realtor Beverly Carter was found dead after being kidnapped from an open house she was hosting.
I'm a realtor. I was showing homes, and someone just robbed me.
And in Florida, 2 realtors robbed at gunpoint while showing homes to a burglar.
Is there something that you're in the back of your mind thinking, if something happens, this is what I'm going to do?
I always have my cell phone with me, and I generally have my hand always on the emergency button.
Realtors agree in this business known for its open door policy.
She always has her hand on the emergency button. Well, there are some like that Supra showing application. Remember, I showed you how to use that app to open the Supra lockbox. There's an emergency button on there where you could preset somebody, and you just press the emergency button once, and it sends out an emergency message to someone. There's also another app that you guys have for free that you guys already have on your cell phones. It's built by default in all Android and Apple phones that you guys can set up. If you drag down from the top, you could go into your settings, just write down what it's called, and you can look it up. You can search it in your settings, or you can search online on how to set it up on your particular phone. It's called SOS, Save Our Souls. So SOS is an application that is built by default into all Android and Apple phones. They're basically, when you tap once you got it set up and turned on, if you tap the power button several times quickly in succession, it'll snap photos using the back camera and the front camera and send out your GPS location coordinates, and it'll record, it'll snap out 5 pictures and record about 5 to 10 seconds of audio. And it'll send it out to your contacts that you set up who you want to get that notification. sure that if you do tap the power button, that you're not pointing it at the floor, but actually at the person that's there if you're ever in trouble. This could deal with you when you're not working in real estate. If you ever come across emergency situations, a lot of people don't even know they have this built into their phones. And that's you just tap it a couple of times like that, snaps the pictures of that person, does the recording, sends out the text message with all that information to your emergency contact. Okay. Just be careful about dialing it by mistake. I ride motorcycles, and sometimes I go on these rides, and I got a phone holder on the motorcycle that there's a rubber band that actually goes around the area where my power button is. So sometimes I've mistakenly hit that, later on after my ride, I see that I got all these text messages from my brother, my sister, my mother. They're like, "What's going on? What's going on?" And I was like, "What?" And they're like, "We got these emergency messages from you." And I was like, "Oh, obviously I'm okay, because if you looked at the pictures, I'm riding my motorcycle and I got a big smile on my face, So obviously I'm fine and I'm okay, But anyway, they were sending out. Why are they getting that message? So,
Question. So that lock, the lock has any emergency?
Not on the lock box.
Okay.
The application on your cell phone that's used to open the lock box. You could see there's an emergency button on that, but you would have to keep that application open, and then you just press the button and it sends out a text message. But that's not recording audio or taking pictures. And you gotta also realize the limitations to that, But even if you got the one that's by default in your phone, snapping pictures of somebody and recording the audio is not going to stop them from kidnapping you or stabbing you or doing whatever. Realize the limitations to these security features. They may be helpful in tracking these people down later, but your immediate safety is important. Now, things happening to real estate agents, it's rare. There are and it does happen more than in other industries where somebody's sitting in their office cubicle, because you're dealing with a lot of people in the general public. Look, just even if you have a relationship already set up with the persons that you're working with. I remember there was an instance this was a couple of years before I even got in the real estate business, but I looked it up. I couldn't find any additional stuff, but I found an old article about it. In Island, there was a case where there was a real estate agent who she had a listing with a husband and wife to sell their house, and they got it under contract and everything, and the husband wanted the real estate agent to come to the house because he wanted to discuss something before the closing with her. Now, I don't know what the argument was about or what the issue was or why he lured her there to the house, but something horrible happened. The guy doused her in gasoline and lit her on fire in the house. He had gasoline on himself too, and he burnt up too, and he died, and the house burnt down. So nobody knows why this happened, what the issue was. All we know is that he sent her a message that he wanted to talk to her, had her come to the house, and he died, she died. So it does, stuff like this does happen, although rare. It does happen. So always have your sixth sense on and be aware of your surroundings. Okay. So
safety is key. Lindsay Davis, ABC News, New York.
Look at that. We resumed that video and they said safety is key, and that is true. Okay. Now here's an instance where it's caught on camera where an agent gets assaulted. I don't know the reason for it or what the guy was trying to do, what he was trying to rob her of, but
what happened? A California realtor is recovering tonight after being attacked during an open house Sunday. Her attacker is still on the loose. And tonight, Fox 4's Rochelle Aline is live in the newsroom with why one realtor says this is a risk realtors face every day.
And Jane, as you're going to see pretty soon, it's tough video to watch, but that realtor tells me that this serves as an important reminder of those dangers that you said that they face every single day. Blood-curdling screams that are hard to hear and video that's even harder to watch. A realtor in Los Angeles attacked at an open house earlier this week, and it's all caught on camera.
I see him all the time. He's in front of me. I didn't sleep last night.
We showed the video to a local realtor, Sandra Wall, who says the dangers are all too real.
Now, the screams are probably got a super short attack right there. I don't think he even had a chance to steal anything from her. If anything, he got a ring or something, I mean, nobody should be getting attacked, but this is just an example of how news, blood-curdling screams, and if you see how they keep replaying the screams, because they sound horrible, and it's horrible anybody getting attacked, but the idea of it, you could see that the attack lasted a couple of seconds, but probably being that loud and that scream, she probably startled the hell out of him and scared him away because of that. But nonetheless, let's listen to the story.
My very first open house was a vacant house. And one of the things that they warn you is if somebody shows up at the very end of an open house and wants to see it, that's a red flag.
In her case.
Okay. Remember, had the legal carry permit to carry a gun. That guy showed up at the beginning of the open house. So it's, she's talking about one of the things usually happen. You always warn about the end of the open house. If somebody shows up at the end, that's a red flag. It's not. You guys just have to always have your sixth sense on about and be worried, be careful about it around anybody. But in my experience, most of the open houses I did, not all of them, but most of them that I did, they were probably dead for the first half of the open house, and then it started getting busy towards the end. So that whole thing about it's a red flag towards the end. People are just procrastinators too. They may have just came out later. So always just keep your sixth sense on.
Someone did show up and used his car to block hers in the driveway of that home.
I had him go into the house. I didn't go in. I stood at the foyer, and he did call from the back room, said he didn't like the view, and I said, that's okay. The view is actually out on the lanai.
Thankfully, that man left shortly after. Wall says she learned some safety tips like creating distance between you and a potential attacker in a realtor orientation. Here's a few more tips she says she still uses to this day.
Keep the client in front of you, not behind you. Be really aware of your surroundings. Try to go with your instincts. Your instincts are usually right. If you feel like you're some kind of danger, there probably is, and better to be safe than sorry.
And coming up at 11 o'clock, you'll hear from a martial arts expert who shares some safety tips we should all keep in mind.
Okay, well, speaking of that,
what happened?
You guys ever hear of Barbara Cochran from Shark Tank? That it was a little old lady used to be on Shark Tank, skinny little thing. Well, she actually made her millions in selling her real estate brokerage. So she gives a bunch of real estate tips in this video here. Let me get my Zoom controls out of the way so that I could control this here.
Hard to believe, but even in this cold snap, people are already getting ready for it, putting their houses on the market. As I mentioned, March is the most popular month to do it. But along with it come those open houses. But here's the question tonight. Are you opening your home to someone looking for something else? Here's Rebecca Jarvis.
Real estate agents are starting to salivate. Home sales are up, interest rates are low, and the economy is improving. You'd think they'd all be out there staging homes and prepping listings, right?
Throw. Listen.
So why is this room full of agents in New Jersey learning how to stab someone in the eye?
My thumb is in your eye socket.
They're taking a self-defense course specifically tailored for real estate agents because their job can be downright dangerous.
Being in the real estate business is one of the most high-risk businesses in the nation, and yet people don't know about it.
Real estate mogul and Shark Tank star Barbara Corcoran says you never know who exactly will be coming to check out that listing, and they may be walking away with more than the property fact sheet. There's been a recent rash of open house ripoffs, like this woman caught pilfering prescription pills from an open house and charged with felony drug possession. So what's a homeowner to do?
Medication's so valuable.
The wrong person is going to take it.
Of course they're going to take it, so you must lock it up.
Now check out this guy facing multiple burglary charges for sauntering out of open houses with high-end jewelry. His lawyer told ABC News his client is innocent until proven guilty.
There's nothing wrong with leaving out a jewelry box, but make sure you have junk jewelry inside, not the real deal.
Why junk jewelry?
Because if you empty out the whole jewelry box, someone sees it, oh, there's the jewelry, oh, it's not here, they'll start looking to find out where the jewelry is.
But the danger isn't limited to homeowners.
Police say the realtor who was kidnapped was traumatized.
The agent you've hired to help you buy or sell your house could easily end up on the 5 o'clock news.
A local real estate agent says he did not think he would live to see his family again.
And it's not just dangerous, it can be deadly. In the last decade, more than 20 real estate agents were murdered, according to the U.S. Bureau of Labor Statistics. Take the case of Beverly Carter, an experienced real estate agent who disappeared from a Little Rock area house she was showing last October while allegedly meeting a potential cash buyer.
Did you kill Beverly Carter?
No.
After a days-long search, her body was found in a shallow grave. The man accused of her murder giving a perp walk statement and later pleading not guilty to capital murder.
Why Beverly?
She was a rich broker.
Are real estate agents sitting ducks?
They are. Nothing is more essential to the real estate business than a new customer. And a new customer could be a good customer, or it could be the wrong customer.
And it's mostly female agents who are meeting Mr. Wrong Customer. Women make up 60% of the real estate agent population, and it is a requirement of the job to market yourself relentlessly to perfect strangers.
They know more about you than you would ever know about them when they show up at your home.
Their cell number is on the business card. It's online. They blog about particular open houses. They talk about their children. And being open like that, of course, makes them a lot more vulnerable.
Hey, morning, Trace.
San Antonio real estate agent Janice Tisdale had always been cautious, but a few years ago, she found herself in a perilous situation with a client and barely escaped with her life. It was a few days before Christmas, and Tisdale had arranged to meet this man, Emilio Maldonado, and his banker in a remote subdivision.
As soon as I pulled up, I said, "Where's your banker?" And he goes, "Oh, he couldn't come today." And I thought, oh, this is weird.
Tisdale did a lot of things right that day. She took off her diamond jewelry and made sure she had an escape route, just like Barbara Corcoran recommends.
I make sure, foremost, that I have an exit strategy. I open the gates on the back of the house. I open the back door.
So if you were showing me this home,
I would say, have a look at the bedroom.
and you would make sure you're there.
I keep my eye on you, but I want to stay by the door.
Corcoran says agents should realize they're already armed for combat.
You should have a cell phone in one hand, and in your other hand, you should carry your car keys. This doesn't look like it's a bad weapon, but cut someone in the face with it, you buy a few seconds to make your runaway.
As Tisdale and her client toured the vacant house, Tisdale's instincts were telling her to bolt.
And finally I said, we really need to go. And I reached down to pick up it was a lockbox. That's when he struck me over the head.
Maldonado was wielding a tire thumper used by long-haul truckers to check tire pressure, and now blood was gushing from the back of Tisdale's head. Maldonado held the 64-year-old grandmother hostage for 45 minutes until she was finally able to use her remaining strength to break away.
I was screaming. I just thought, you're dead, Janice. You are dead.
In the distance, Tisdale spotted some teenagers driving a banged-up Honda Civic.
And here come those kids, and their window was down. So I just screamed, help me, help me. He's trying to kill me. And they slammed on their brakes, and 5 teenagers bounded out of this car.
Maldonado was arrested soon after. Now he's serving 60 years for aggravated robbery. And as for the teens who came to Janice Tisdale's rescue,
I have 5 more children now, so instead of 4, I have 9. What more could a mother want?
well, actually, this mother wants one more protective friend. These days when she shows properties, she brings along a Beretta Tomcat.
I'm so happy you're alive. Amazing.
Thank you.
Yeah, just wonderful.
The shark and the survivor spoke via Skype.
I hear you teach all the new realtors what to be careful about. I bet one of the big lessons you're teaching is trust your gut.
That is the thing I end with, is trust your gut, because if you don't, you could end up dead, or you could have staples in your head like I did. Get off!
And that's why it may be good to get this kind of training. Wow.
I can take
In case you have to take matters
Please don't hurt me. Please don't hurt me. Yay!
into your own hands.
It's like much more comforting to have this knowledge and to know I'm not helpless and how to get away.
And Barbara Corcoran has a lot more safety tips for selling your house safely. You can find them on our 2020 Facebook page.
Barbara always knows.
She does.
Hard to believe.
Right, so, I showed you these videos to give you some examples of stuff that actually happens, but here's some more resources for you on NAR's website, the National Association of Realtors. They have this section here about windows to the law. It has a bunch of videos about various topics. And they also have this nar.realtor/safety resource, which has access to all kinds of software and services and apps and things, and that could be used for at open houses or for safety or for all kinds of other real estate related issues too. This is actually a good video that you should send out to home sellers or maybe even home buyers when you're first dealing with home buyers. This is a good video to send out to them because it explains to them everything that you probably were taking notes on about the safety.
Real estate professionals are in a unique position that most working professionals never face. They often share their contact information openly with others, meet unknown clients, and walk through vacant properties, to name a few. It's because of the unique nature of this business that it's critical for all real estate professionals to have a personal safety protocol in place that they follow every day, with every client, every time. And that includes with you. So, what kind of safety protocols might your real estate agent take? When meeting you for the first time, your agent might not meet you at the property right away without first having an initial meeting at the office, regardless of you or your agent's gender. You wouldn't want to meet a stranger at an unknown location, would you?
Hey, how you doing?
No. During the initial meeting, your agent may make copies of your driver's license and pre-approval letter for their records. This precaution allows the agent to keep a record at the office of who his or her clients are and a calendar of appointments. When first meeting with your agent, you'll also discuss the types of real estate you're interested in and walk you through the process. Now your agent can arrange showings, meet you at properties, and schedule open houses to help you through the biggest financial decision of your life. When viewing a property, your agent may ask that you drive separately. Please don't be offended. This is a safety precaution for you as much as it is for your agent. Not to mention you may both have appointments to go to afterward.
Hey, this is cute.
When viewing a property, you may need to sign in with your name and phone number or show a photo ID. This is so the seller's agent knows who entered the house. If you were opening your home to strangers, you'd want to know who was there too. As you tour a property, your agent may walk behind you. This is not only a routine safety measure, it also allows you to see the room first and make your own impressions. And many agents won't go into attics, garages, or basements, but feel free to look around and let your agent know what you thought. If you want to see a property that's vacant,
It's got potential.
your agent may only show it during daylight hours. Vacant properties should be seen during the day when you can see what safety hazards may exist, like a loose floorboard or any defects the house may have, like mold. When showing your property or hosting an open house, before opening your home to potential buyers, your agent may ask you to board your pets and remove jewelry, family photos, credit card receipts, artwork, prescription drugs, and valued possessions from the home. This is just one way your agent is looking out for you to keep your property and belongings secure. Your agent may bring a colleague to host your open house. If there are several potential buyers walking through the home, even better to have 2 agents on hand to answer questions and keep an eye on things. Safety is an important part of real estate, and we appreciate you respecting the protocols and processes that have been put into place to keep you and your agent safe.
That was a pretty informative video. It's pretty good. Another reason to meet clients, potential clients, first at your office is to get them pre-qualified for a mortgage, right? Get them on the phone with a mortgage rep. And the way you do this, don't make it all about you and your safety. Also make it about them and what they get out of it. Tell them, hey, listen, you come into the office, we could get you on the phone, or maybe we have a mortgage rep already here. They could run your credit and see what you qualify, run the numbers based on your income and expenses, and you could get an idea of how much you could afford to buy, and know what your monthly mortgage payment is. Wouldn't you like to know what your monthly mortgage payment would be to see if it's something that you find affordable? You know, so you gotta frame it in a way that it's something you're giving them too. You know. All right, and just one of the windows to the law, talking about using mace and weapons and all kinds of stuff like that. I think this is mainly talking about pepper spray and things and being aware of the laws in your state. You know, I know New Jersey recently they found that tasers are legal. That is true. That's another one of those things where they're trying to outlaw these self-defense things, these tasers. But even though they were legal in New Jersey, politicians in New Jersey are hell-bent on ignoring and defying the Supreme Court. And when it comes to any kinds of self-defense for law-abiding citizens, and they refuse to change the written law. So it was already overturned in the Supreme Court, but it's still written in our law books in New Jersey that they're illegal, even though they are legal. They've been deemed legal by the Supreme Court. The only thing about it is they're legal in your house. New Jersey doesn't allow you to carry them with you. Kind of defeats the purpose of self-defense, right? Unless somebody's breaking into your house. But New Jersey has a lot of weird laws. You know, if you carry around a pencil in your back pocket and you use it as a weapon, if you had that pencil in your back pocket and you intended to use it as a weapon, you had an illegal weapon on you. You could be charged with that. It's the dumbest. Oh. It's the dumbest thing. It's like our politicians put together laws to try to make it so that you're defenseless.
Hi, I'm Deanne Romarowitz, Associate Counsel at NAR. Realtor safety is a top concern. According to the 2020 NAR Member Safety Report, 1/3 of NAR members felt unsafe at a showing or an open house. By taking proper precautions, such as the ones I'll highlight in this video, real estate professionals can stay safe while they work. First, create a personal safety plan that addresses common scenarios that can place real estate professionals in potentially risky situations, such as meeting new clients, showing properties, or hosting an open house. For example, the safety plan could include practices like driving separately from clients, arriving early to unlock doors and note escape routes, avoiding accompanying clients into basements, garages, and attics, and letting someone know where you are and who you're with at all times. Include any office safety protocols in your safety plan and be familiar with available safety tools and education provided by your brokerage. If you choose to include self-defense spray, such as pepper spray or mace in your safety plan, be familiar with and comply with all applicable regulations for the purchase, registration, and use of such sprays. These regulations can vary widely. For example, Hawaii requires a license for pepper spray and limits the container size to a 1/2 ounce. Wisconsin limits the active ingredient in pepper spray to a 10% concentration and a 2-ounce container. Second, Consider using available technology solutions to help keep you safe. At the touch of a button, web tools and smartphone apps can confirm a stranger's identity, conduct instant background checks, and even send your GPS coordinates and alert contacts if you are in distress. Be aware of the terms and conditions and limitations on the tools and apps that you use. For example, an instant background check cannot be used for any discriminatory purpose or to make decisions based on credit, tenant screening, or for any other purpose that would require compliance with the Fair Credit Reporting Act. Third, be sure to apply your safety practices evenly and never use any information obtained in a discriminatory manner. Consistently applying safety protocols with client interactions will help avoid legal liability, including under the fair housing laws, which protect individuals from discrimination in connection with the purchase or rental of housing. Finally, immediately report incidents to local law enforcement and keep up to date on safety alerts through the Realtor Safety Network. The Realtor Safety Network issues alerts via social media about incidents of safety concern and emergencies warranting national attention, including physical threats to a realtor's safety or when a realtor or their immediate family member goes missing.
All that does is send out a notification on social media like Facebook. You know, it's that's like we got notifications like that when there was a couple that was going office to office posing as buyer clients, and they were just walking around, and if they saw a real estate agent's pocketbook sitting on the back of a chair, they'd snag it or they'd steal a laptop or something like that, you know, and they sent out a notification on this network and it let everybody know. But otherwise, that's kind of a waste of time, that one.
You can report incidents.
So anyway, we got these links here, and I got all these links once again in the that class links Word document, and you can find them on these slideshows. There, I have another slideshow right here that has all of these links available for you. Like the member safety tips video, this is the link that took you there. The setup, how to set up that free SOS feature on your Android and iPhones. You could get it by watching this video. This one's not a video for the Apple phone. It's just a guide. But if you can just do a Google search really quick, and you could see how to set up the SOS on my, and then put in your phone type. And it'll show you how to set up SOS feature. It's a free feature that's on your phone. Here, I'll give you a little quick rundown of this.
For your personal safety, the latest Galaxy smartphones come with an emergency SOS feature. In 3 taps, you can trigger an SOS message to your emergency contacts. To set up emergency SOS on your phone, pull down your notification bar and open Settings. Scroll down and select Advanced Features.
At
the bottom of the menu.
Let me stop it right here. You can also just click the search bar. You can just click the eyeglass after you go into the settings. You click on that search eyeglass there and put in SOS, and it'll automatically take you to where you need to go.
Tap Send SOS Messages. Toggle it on, and then choose your emergency contacts who will receive the message when you trigger an SOS.
You can even set up the message that you're going to send.
You can also opt to automatically send a 5-second audio recording and photos using the front and rear cameras. Trigger your SOS by quickly pressing on the side key 3 times. When you trigger your SOS, your emergency contacts will receive your location, audio clip, and photos, allowing them to check on your safety.
You can also set it up to send a message now. as in addition to that. And I usually put down there as a message, contact the police, send help, I'm in danger, but first try to reach out to me in case I've butt dialed, in case it's a mistake. All right, so that's that. All right, so tools like this, Forewarn. This is a tool. It's a cell phone app you can put on your cell phone for $20 a month for agents to do instant background checks, criminal background checks on people. This is actually now free to members of the Mid-Jersey Association of Realtors. If you become a member of the Mid-Jersey Association of Realtors, it's actually a free benefit that you get now. You can download the app and get access to it for free. Where you could then do unlimited criminal background searches on people. So you're meeting a client or something, you could run a background check on them. If they seem kind of sketchy, bring somebody along with you, or give the lead to someone else to take it out as a referral. Let me see. Listen, I know they're always talking about, worry about discrimination. Don't use things for discriminatory purposes and all that. Listen, guys, always deal with your own safety. If somebody seems sketchy to you, worry about your own safety first. Okay. All right. Let's see. Here's that NAR safety resource page. Once again, all of these links are in that class links Word document that I have for you. But what I'm going to do right now is I'm just going to share all of these with you in the chat window. How about that?
Mm-hmm.
There you go. You got all those links from that slide right now. So if you were just to click on that chat window, it's probably flashing or has a red notification there that you got a message now. It's an instant messenger we got here in this app. All right, moving along. Let's continue with the lesson. Enough about realtor safety. So the broker salesperson relationship between you and your brokers. You're responsible. Look, you work for your broker. Don't go bad mouthing them. Okay. If you don't get along with them, you don't work for your leave. Okay, go somewhere else. But still don't go bad mouthing them, because you may still have to deal with these people if you're going to be working in this business. And I've seen situations before where you got brokers from different brokerages, they hate each other. And they project that hate through their agents too. Now, all of a sudden, their agents hate the agents from the other brokerage firm, and they don't even know why. It's because of the two brokers that were fighting with each other, and this became an issue for me one time because one of the brokers I used to work for was like that. So I called up to say, I'm not involved in that crap, and I don't want to be. It's drama. So I called up that other agent that he didn't get along with, and I called up her agency, and she actually picked up the phone. She's the broker of record. She actually picked up the phone, and we had a pleasant conversation talking about her listing. It was her listing, and we had a pleasant conversation about it all. And they're wanting to set up an appointment, and she was like, "Okay, yeah, sure." She was very sweet. And then I told her what brokerage I was from. Then all of a sudden, I instantly can hear her demeanor change over the phone on how she was talking to me. And I was like, "Wait, hold on a second, please. Hold on for 1 second. I know you have issues with my broker and he has issues with you. I don't know what they are. I do not care." I was like, we were having a pleasant conversation, you and I. I don't have any problems or issues with you. And you shouldn't have any problems or issues with me. Whatever's between you and my broker, that's between you guys. I found you to be very pleasant in our conversation, and I don't have any issue with you. So let's please not let that, taint this here. I don't have any problems with you. I just want to show the property to my clients. Maybe we could work together and sell this house, And so then after I talked her down to planet Earth, because she instantly blew up on me, and I was just like, oh, what did I do, So we were able to repair that by me not blowing up on her in exchange and just working it out. So yeah, there's drama like that in this industry too. So salesperson has no authority to make any transactions or receive compensation directly on their own, right? You do that because you through your relationship with your brokers. Salesperson is an agent of the broker and a subagent of the principal. You're both representing, you're an agent of an agent, that's what a subagent is, and you're both representing the principal, which is the client. Independent contractor versus employee is the next thing we're going to go over here. You guys know the difference between an independent contractor and an employee? I know Raphael does. You being an accountant and all, right? Helping people with their tax stuff. It's for taxation purposes. Independent contractor versus employee, but it's a little bit more beyond that. When you're an independent contractor, you're essentially self-employed. Okay.
Self-employed, right.
But when you do get paid, your broker pays you the gross, not the net.
Employee.
They're not deducting any expenses. So, you know, your Social Security, your unemployment, all that stuff that, you know, your SSI, all that stuff, they don't take that out of your pay. They pay you the gross. But you still need to pay these expenses. So when you get paid your commission from your brokers, don't spend it all. Put some of that money aside. Talk to your accountants about how much money you should put aside from each of your transactions, because you're going to need to set some of that money aside to make those payments at the end of the year when you file your taxes. I actually have it written down somewhere. I got the book and I got all kinds of crap here. I actually have the exact amount written down somewhere. But I forget what it is. I think it's something around 15%. Okay. Take some of that money and put it to the side for paying your taxes at the end of the year. You know, talk to your accountants about that, what your particular tax situation is, and how much money you need to put aside for those important payments. Because otherwise, at the end of the year, you're going to file your taxes. Now all of a sudden you're going to have to pay taxes on all that money that you made that they didn't take the taxes out yet. So don't go spending it all. You know, put a portion of it off to the side so that you could pay the tax man at the end of the year. Okay. So that's the independent contractor, is basically self-employed. Your broker cannot require you to work specific hours as an independent contractor. If your broker required you to work specific hours, you just became an employee. They can't require you to attend mandatory floor time to act as their unpaid secretary, or attend events. You'll be responsible for providing and paying some of your own expenses, which could be tax deductible too, like the tools and services you use. Remember, track your expenses so you can write them off in your taxes at the end of the year. Having a program like QuickBooks Self-Employed version, that could help you track all of your expenses. You could snap pictures of your receipts. You could keep track of everything. It makes it easier to file your taxes at the end of the year and work with your accountants as well. Income taxes you need to pay, the licensing fees, this class, the fee you paid for this class, all this stuff is tax deductible for you. It's a business expense. You're going to need to carry errors and omissions insurance. We didn't get into that yet. When you start working, it's like the equivalent to the real estate industry, what the medical malpractice insurance that a doctor would carry. Okay, we need to have that errors and omissions insurance. Your broker usually carries a policy for X amount of agents that work at their office, and periodically they submit a list of names of agents that are working in their office to the insurance company. But either way, they're covered based on the number of agents. So your broker already pays for a policy, but they're going to bill you for your share of it when you start working for them. So that's another interview question to ask your brokers when you start interviewing for brokers where you want to work. How much is your errors and omissions insurance? And do I got to pay for it up front? Or can you take it out of my first transaction? Because often it's a pretty big nut to carry. It's often between $450 and $600 a year. And it's usually more along the lines of $600 a year. All right. And if they require you to pay that up front, that's a lot of money, you know? So, when interviewing, ask the brokers about this. Now, some brokers have errors and omissions insurance plans where you make small payments per transaction. Now, use caution with those, because if you start getting busy and doing a lot of work, it actually becomes more expensive. Okay. It may sound okay. Oh, I don't pay that much. I only pay when I do a closing. Yeah, but the more closings you start doing now, the more money you end up paying out the door. Any membership fees for MLSs or Realtors Association dues, tracking your education expenses. If you want health insurance, well, you're going to have to pay for that on your own. Your broker does not pay for that because you'd be an employee if they paid or contributed anything to it. Tools, equipment, and services you need. Your brokers are not going to provide those to you. In other words, like your membership to the MLS. The only kinds of tools and things that they'll have the signs. You don't need to go out buying signs or lockboxes. Your broker will purchase these and have these available for you to use. So your broker does have some tools and resources. They got software on the general computers in their office that you have access to. But anything specific that you want, you're going to need to get it on your own. So quick tools like QuickBooks Self-Employed or FreshBooks, these are great ways. FreshBooks is another thing. It's kind of like QuickBooks, okay? Way for you to track all of your expenses and everything so you can file your taxes. Even your vehicle, you know, you could write off your vehicle if you're using it for, you could write off your lease expense or your purchase expense, your maintenance, your gas, all that stuff. You could write that off on your taxes if it was only used for business purposes. However, most likely you're going to be using it for personal reasons as well as business purposes. So for IRS rules, you either take a standard deduction or you track your mileage. And these tools, QuickBooks Self-Employed and FreshBooks, they actually have a mileage tracker. When you start moving and you got your cell phone with you and you got the app installed, when you start moving faster than a human can walk, something will pop up, a notification pops up and says, we notice you're taking a trip. Is this a business trip? And now you select yes. Okay, and then you could associate them to a client, or you could fill that information in later and it'll just track your driving. Okay, and then later on, it'll keep it for your tax records. So it's pretty good. Okay, so an employee works for someone else and their employer pays for all their tools that are required to perform their job. They pay taxes, insurance. They may be paid an hourly wage. You guys are not going to get paid unless you guys are going to get paid on a commission basis, most likely. Okay. There are some jobs out there that may pay you a stipend, and then when you do a closing, you have to pay that money back to the broker. You know, so they're like advances on your commission. Okay, that's usually with like property management companies or commercial transactions with commercial brokerages. But listen, once you get a real estate license, there's a lot of areas in real estate that you could start working in. You could go in property management. You could work for builders. You could work for low income and affordable housing builders and groups like that. And don't shy away from that and be like, oh, I only want to sell those $1 million mansions, you know. Well, that's harder to do. You got to deal with people that are particular. Let's leave it at that. And, you know, but you can make a lot of money still dealing with low income and affordable housing. If you deal with those builders and such, there's a lot of money to be had there. You know, I taught a broker's class one time, and I had this one lady when we got to this point, and she was like, I got a question. And I was like, okay, what's the question? And she's like, what does the MLS look like? And everybody in classroom shot her a look. They're like, and then they're all, pss, 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 pss. You know, it's like, how can you work in the real estate agent industry for so many years and you don't even know what the MLS looks like? You know, and like they're like laughing at her, you know? And I was like, oh, hold on, guys. So I picked out this one guy who was wearing a suit. He came to classes, real estate classes, in a suit every day, you know. And I was like, in your best year, how much money did you make? You know, and this guy's like, well, I kind of almost average it, but $150,000. And I already had a conversation with her, and I already knew that she was working in affordable and low-income housing. She was the only agent that was working for this developer doing the low-income and affordable housing. And I already knew how much she made. So I was going to make it a little example of him in the classroom for making fun of her. So I asked him, I was like, I asked her, I said, and how much did you make last year? And she's like, well, you know, and I was like, no, just give me a rough estimate. How much did you make last year? And she said, it was about 300,000 for low income and affordable housing. She made $300,000, you know? So I told them, and all of a sudden they were like, how do you get involved in that? What do you got to do? What do you got? Like all of a sudden they were just making fun of her. Now all of a sudden they're because she didn't know what the MLS looked like because she didn't use those tools. But she had a particular set of skills that she had to learn about qualifying people to get into affordable and low income housing. You know, so don't ever look down on things like that or people that are working for different particular areas within the real estate industry. You may discount them, but there's money to be had. All right, so let's just copy these notes. Most real estate salespeople act as independent contractors. This is on page 34. Independent contractors assume responsibility for paying their own income and Social Security taxes. That's on the last two lines of page 34. Okay. Now, the IRS has rules in place to determine if somebody's an independent contractor or an employee. They call them safe harbor rules. And it's basically a couple of questions. And if any of these situations apply to you, you would be an employee and not an independent contractor. Right now, we have an issue in New Jersey. Once again, I do bring politics up quite a bit in this class, but I don't care what your politics are. Okay. The reason why I'm bringing them up, I just want you to be aware of how politics plays a role in real estate. And our current governor, for some reason, he's trying to do away with independent contractor status. He wants everybody to be a member of a big corporation. And, you know, the politicians talk a big game about, oh, I'm for the small business. I'm for the little guy. Those other ones, this Wall Street. And then they turn around, look at the actions that they do. Our current governor, he tried this in the past, but then he put it on hold because an election was coming up and then he never brought it back. But he's trying to revisit the issue now before he leaves office. Like all these other taxes that he's raising and creating on his way out. He's allowing electric companies to raise the prices on our electricity. He's allowing, you know, putting all these different laws in place that are making it a lot more expensive to live here in New Jersey. Well, for some reason, he's trying to do away with the independent contractor status. And how is that going to affect us in the real estate business if he's successful in doing this? I don't think he will be, but we got to keep an eye on it because it could totally change anybody who's self-employed, how they do business. And it can make it a lot more expensive for you to work, or you're not going to be able to work for yourself. You're going to have to work for someone else. All right. So just keep an eye out on when you hear about New Jersey doing away with independent contractor status, listen to the news. Keep your ears on the news there, guys. So independent contractors receive nothing from their brokers that could be considered an employee benefit. You know, once again, you guys see highlights on screen, highlight them. Don't wait for me to tell you to highlight them, okay? You see highlights and notes from the screenshots from the book, do them in your book, okay? So brokers cannot require independent contractors to work certain hours, attend office meetings, or pay them a salary or hourly wage for that matter. We get paid per transaction. So the IRS has these safe harbor guidelines, which determine if you could be an independent contractor or if you're considered an employee. Now, as far as questions on exams go, they'll probably you just got to be aware that you're not going to be getting paid a salary. And your broker cannot have mandatory office meetings or dictate how you perform your job, other than within the guidelines of the law. Okay? They're supposed to give you that guidance and direction, but they can't tell you how you need to do your job specifically, other than keep it within the guidelines of the law. So if you're an independent contractor, your broker cannot require you to work certain hours, have mandatory floor time, attend mandatory office meetings. You also can't receive any benefits or salary or hourly wages. You'll be paid on a per job basis.
Oh, that we have to write it down? If you are an individual, your broker can require.
As long as you understand it. You know, you guys highlighted enough stuff that talks about things like that. I just spelled it out. You know. Okay. So a sample independent contractor agreement is on page 37. That's why I have page 37 written here.
Mm-hmm.
Because I give cross references for everything in my notes. All right. So your broker is the head honcho. Then you work under the broker as salespeople. Now, what determines whether you're an employee or independent contractor? You could follow this guide. Employees must have their income tax, Social Security, and unemployment tax withheld by their broker. They could receive employee benefits, and they must adhere to office regulations. Independent contractors assume responsibility for paying their own income tax and Social Security, or health insurance if such coverage is desired. They cannot receive any employee benefits whatsoever from the broker. However, they can be told what company expectations are.
So we can work as an independent contractor also, right?
You will be working as an independent contractor, most likely. Like 98% of people in the real estate industry. Okay. I mean, you may get a job working for somebody in property management where they're giving you a salary, you know, but then you'd be an employee. But that's not the majority of people with real estate licenses.
So we can work as a salesperson under the broker or independent contractor, right?
Depending on who you're working with, yes. But most likely you're going to be an independent contractor. So for exams, you're an independent contractor. Stick to that because they go with what the majority is in that case, okay? So commission is considered when you produced a ready, willing, and able buyer, and your clients were under contract. The broker may be entitled to a commission even if the transaction's not consummated. Maybe the deal fell apart due to your client's breach of contract. That breach of contract means your clients broke the contract without having a good legal excuse to do so. These are just things that are coming up in the coming slides. We're going to learn what a procuring cause is, although we did in an earlier chapter, but we're going to mention it again here in this chapter. Procuring cause is when there's two buyer's agents that are in dispute as to which one is owed the commission, because they're the ones that did the most work leading to the sale, being the procuring cause of the sale. Therefore, they're the one that's owed the commission. So we're going to go over procuring cause. And a meeting of the minds. That's when we negotiate with each other back and forth, and when we come to a final agreement, it said we've come to a meeting of the minds. You know, we're on the same level here now, right? And commissions between the broker and licensee is established at the time they hire you, the time of employment, in your independent contractor's agreement. So let's highlight on page 35. After a listing broker procures a ready, willing, and able buyer, seller is technically liable to the broker for their commission. A ready, willing, and able buyer is one who's prepared to buy on the seller's terms, they're financially capable, and they're ready to take positive steps towards consummation of the transaction. All right, now, so in some cases, if the deal falls apart due to no fault of yours, but your clients maybe breached the contract, so they became in a legally binding contract with each other, the seller and the buyer, and one of them broke the contractual terms without having a good legal excuse to do so. It's said that they're in breach of contract. Technically, we're owed our commission now. However, they're probably not going to volunteer to pay it. You're probably going to have to sue them to get it. And do we get good reputations generally from suing clients who change their mind about buying real estate or selling their house? Probably not. What if it was a $10 million deal? Sue. What changed? Well, the juice all of a sudden became worth the squeeze. That's what happened. All right. So that's between you and your brokers about whether you're going to sue your clients or not because they broke a contractual terms in order to collect your commissions. So here's some of the instances where you would be entitled to a commission if the deal falls apart because your client's breach of contract. If the owner simply changes their mind and they refuse to sell, or the buyer refuses to buy at the last minute at the closing table, they change their mind, they don't want to sign the documents. There's defects in the owner's title that were not corrected. Okay, so when the seller puts their property on the market for sale, they agree to sell you their property that's free and clear of any liens or encumbrances. A lien is a financial obligation on the property. Liens attached to the property, not to the property owner. So if you're purchasing someone's property and there's liens on there that the seller didn't clear up because there was some bill they got from a contractor, for example, who did work on their house and they never paid them, would you want to buy a house and then have to take on the obligation to pay back that contractor? Probably not. No. So that's one reason why a deal would fall apart, but that's due to the breach of the seller. Breach of contract. The owner commits fraud with respect to the transaction. Oh, I don't know. Maybe they signed a contract with their girlfriend who was posing to be their wife, like the example I gave you guys earlier today. Or the owner's unable to deliver possession within a reasonable time. Hey, people collect a lot of stuff over the years, It may take a long time to get all that stuff out. There's ways that we could work with homeowners to give them extensions if they need more time and the buyer's willing to work with them. But there's got to be some kind of a deadline to this. The owner insists on terms in the listing that they did not previously disclose. Like the right to restrict the use of the property. Oh, that's an interesting one. I will get in. In a later chapter, we talk about this stuff, but I could tell you about this right now. Did you know that if you own real estate and you sell that real estate, you could dictate how that real estate can be used or how it cannot be used? And if that future owner ever violates that restriction, you could take them to court and compel them to give you the property back, but you don't pay them nothing because they violated the terms that they agreed to in the sale. This is more often done in commercial real estate, but it can be done in residential. But I'll give you a couple of wacky examples with that. This is often more done in commercial real estate. For example, you got Shell gas station, they want to sell one of their old properties, right? They have no need for it anymore. But they don't want the competition moving in there. So they put a restriction in the deed when they sell the property that this property can never be used as a gas station again. Or they could craft it a different way. They could say this property can never be used as a gas station unless it's a Shell gas station. Okay, so basically, they sell one of their old properties. That'd be fine for somebody who's going to convert it to an office building. They don't care about that. They're not going to have an issue with that. But what if you sell it to somebody who's going to use the building, which is already an auto repair shop, they're going to use it as a garage. Now, years later, they sell the garage. They were in business for years, and then they sell it to someone else who was in business for years. They sell it to someone else, and now this guy got the idea, hey, how about we put a couple gas pumps up front and we start selling gas too? You know, we got the garage here already. We could sell gas. It's in your deed. When it passed on from one owner to the next, each owner's deed, it's said in there, there's a deed restriction that's stipulated how you can or cannot use the property. As long as the restriction is not an illegal restriction, it's enforceable in a court of law, and it could pass on from one owner to the next, to the next, to the next. Okay? You may be able to find, actually, you're probably not going to be able to find them anymore in New Jersey now. One thing that the governor did about 2 years ago is he ordered all record keepers in New Jersey for each of the 21 counties to sift through all the documents in the public records for home ownership for every single home in the state, which they're probably still trying to do complete this task because it's no small task, to sift through every document through history that was ever recorded in the state of New Jersey to make sure there's no discriminatory reference in any deed. Because you could find in real old deeds, something discriminatory like you can't sell the property to a black person. Okay? That's discriminatory. So it's illegal. Obviously, it's not enforceable in a court of law. But you still may be able to find something in old documents that may have an illegal restriction like that. Or maybe one that says you can't sell it to somebody who's not in the family. That's an illegal restriction because it's too restrictive on the owner. So even though they're a family member, maybe they can't afford this property no more or keep it up anymore. Now you're restricting them that they can't sell it. So you're kind of like dooming their financial situation, and there's no way they could ever sell the property. So that's too restrictive. So that's illegal in that regard. But here, there's nothing to stop you having a deed restriction like this where an owner says, I'm going to give this property to my nephew, provided that my nephew graduates from college. But until that happens, there could be no beverages consumed or present on this property. Is there anything illegal about saying you can't have an alcoholic beverage on the property? No. It's kind of a wacky restriction, but there's nothing illegal about it. So if an uncle gives the property to his nephew and he puts in the restriction in the deed that you can't have alcohol on the property until you graduate college, that's a deed restriction he'd have to abide by. And if he violates it, he could take him to court and legally compel him to give him the ownership back. Now, there's nothing to stop his nephew from selling the house, though. So what if uncle, gives the house to his nephew, puts that deed restriction in there, and then the nephew says, fine, I'll sell it. And then he uses the money to buy another house, and he can drink all he wants on it. Well, what about that house that was sold with that deed restriction? If you bought that house that had that deed restriction on there, can you have alcohol on the property? No, you cannot. Because the restriction said no alcohol can be on this property until this nephew of his graduates college. And if he never graduates college, all future owners of that property can never have alcohol on the property. You'd have to track down who that person was, that uncle, and hopefully he's still alive, and get him to remove that as a restriction from the deed. Otherwise, that restriction is there forever. It passes on from one owner to the next owner to the next owner. It can never be removed. Could that affect the saleability of the house? Would you want to buy a house? If if you ever drink, even if it's only on holidays, would you ever want to buy a house that has a restriction there that says you can never have alcoholic beverages in your house? Most people wouldn't. So that could definitely lower the amount of people, your audience, who would want to buy that house. Would that have an effect on the value of the house? Oh, yeah. Any restrictions that limit your ownership rights in that property in any way are definitely going to have an effect on the value of it as well. See, isn't this kind of interesting conversation? I mean, who ever heard of this kind of nonsense, you know? But it's out there, and it's real.
So people put the restriction when they sell? Sometimes they put restriction on it?
Yeah, like I said, it's mostly on commercial real estate, but sometimes you could find restrictions in residential. You know, let me give you another one that's more realistic. We have a lot of land that we own over here somewhere in Jersey, and it's right by the lake. We got a lake on the property. It's beautiful property. We own acres and acres of land. Now, we're going to sell that property. However, we're going to put a restriction in the deed that whoever buys it, we don't want them to end up subdividing it and just putting a bunch of houses around a lake and selling them as lakefront properties and destroying the beautiful nature and scenery. Plus, on the other side of the lake, we usually have a day camp for the kids during the summer, you know, and we would like that. You know, we grew up, it was always like that for us, and my grandparents went there when it was a day camp, and, you know, it's just like it was passed down through the generations, and we had this always as a day camp for all the kids to come and enjoy. So we're going to sell this property with a restriction that it cannot be subdivided and a lot of houses built on it.
Wow.
And they need to keep the day camp open for kids every summer.
Wow.
Okay. There's nothing illegal about those restrictions. And if you agree to those terms when you buy the property, you have to honor them. If you then turn around and start subdividing and building up houses all around the lake, I could take you to court.
Wow.
Compel you to turn the property ownership back over to me. And now I own the property with the houses that you built on it. And I'm not paying you anything for it. Reason being is you violated the terms of the sale. You knew what the restrictions were. You ignored them. That's your problem. Okay.
So it's not like this, that once you have that property, you can do whatever you want. It's not like that.
Well, if there's restrictions on it, you can.
I see.
But if you buy a property, wouldn't you want to know if there are any restrictions on it before you buy it? Knowing now that there could be all kinds of restrictions on properties. I mean, who thinks of that? Most people don't even think about deed restrictions or I've never heard of such a thing before. But it's a thing. It's a thing. You could have restrictions. Look, in one of the coming chapters, we're also going to talk about rights and mineral rights. You could sell your property and keep the mineral rights on it. I had a girl in one of my classes. She sold a property she owned in Texas, and she moved to New Jersey. And she said it's a common thing over there. What you put in the deed is you put a thing that you keep the mineral rights on the property and the right to drill on it and explore it to find the oil. And if you find any oil, because Texas is rich in oil, if you find oil, you know, that's your oil. You own it. You don't own the land anymore. You don't own the real estate. You're not responsible for paying taxes. Whoever bought the property, that's their property. But if you have, you could retain some of the rights. So she kept the mineral and the oil and gas rights, and then she actually leased them out to an oil exploration company. That when they find oil, and they did, that she gets a check every month from them. They split the profits. So they did the exploration. They found the oil. They put up the rig. You know, because there's also a condition there that they're allowed to get it out of the ground, you know, because it's one thing to keep the rights to the minerals in the ground. But if you don't spell in there that you have a right to be on the property to get it out of the ground, what good is it going to help you? You know, so they have the contracts worded a certain way that they're allowed to do that. But interesting stuff that you would have, most people never even think of, right? You think that property, it's your property, I can do whatever the hell I want with it. Other than, of course, any restrictions that your local municipality, your government may put on it, right? Because you got to follow zoning laws. I mean, can I put up a commercial building in the middle of a residential neighborhood? You know, things of that nature. Well, we'll get into those conversations later on. I'm getting way too far off track right now.
Right.
Let's just stay back over here.
Thank you.
That stuff is coming in the next couple chapters, though. So, or the owner just simply agreed both to cancel the transaction. Well, what does that leave us? We put money into marketing the property. We put it on the market. We put our time and effort into it. We could require them to at least pay us back the money that we put out. But at most, you could sue them for your commission too. Because you were hired to produce a ready, willing, and able buyer, right? And you did that. And they were under contract. And they killed the contract. You did what you were hired to do. You should get paid. Right? Okay, so down here, right in here, procuring cause, because I don't believe it says that. No, it does not. So in this section here, do the highlight and then do the writing of this. Procuring cause is the one who is owed the commission. Difficult to prove. And we'll go over them on a next slide I have about procuring cause. And then below that, we have meeting of the minds explanation. This is the definition of it that you need to know for school exam, which was made by the book manufacturer. See, there's two definitions for a meeting of the minds, one for the school exam, one for the state exam. State exam is more a broader definition. It's when the parties are in agreement on all the key terms of the contract. For school exam, they focus more on the financing aspects of it. So it's when the parties are in agreement on price, down payment, and financing method. How you coming up with the rest of the money to buy it, to complete this purchase. Damn, they get rid of that cough.
I'm done with the highlighted, okay?
All right. Everybody got the highlights in the notes here? So, what is a ready, willing, and able buyer? We just highlighted it in the notes. I just got a slide here with the same notes. A ready, willing, and able buyer is a person who is prepared to purchase on the seller's terms. They're financially capable, and they're ready to take positive steps towards consummation of the transaction. Now, we usually don't get paid until the closing, the actual transfer of title takes place. However, if the transaction falls through due to one of the parties' breach of contract, we could still be owed a commission, but we'll probably have to sue to get it. And generally speaking, it's not a good idea to go suing your clients. But I gave you the scenario. What if it's a $10 million, $100 million property? Sue. The Jeep just became like the Squeeze, right? But by the way, that's a metric by which I measure all things by. Before I ever do anything, I ask myself, is the juice worth the squeeze on this? Is the effort worth the outcome? That's basically the term, you know, like fresh squeezed orange juice, right? Is the effort worth the outcome? Yeah. Is the juice worth the squeeze? It's the same meaning. Okay. And here's some of those examples of the breach of contract, which we already just discussed and went over. It's just I have them retyped over here. And I gave my examples here for example of adding restrictions to the deed on how the property can be used by future owners. Okay. Procuring cause. That's when two buyer's agents are in dispute as to who is owed the commission. The one who could prove they did the most work leading up to the sale, causing the sale, will be the one who's owed the commission. but that can be difficult to prove. If you have an exclusive buyer's agency agreement signed with that buyer, it could help establish your evidence that they were not working with that, because there's a question on that document that says, are you currently working with another agent? And if they checked off that they were not, well, clearly then you did all the work. So when exactly did that other agent step in the picture? So this can help establish your evidence as you being the one who caused the sale, and you were the only agent working with the buyer. So when exactly did the other agent step in the picture? It's illegal for us to solicit the business of another broker. With buyers, it's kind of hard to prove. With sellers, hey, we got a listing agreement, so we don't care. We got a contract. You hired us. You pay us if the house sells. Okay. So even if you go and you list that property with another agency, well, good. You still owe us the commission. You're going to have to pay them a commission as well. That's your problem, that you went and hired two companies to sell the same house. You got to read the print in your contracts there. You know, if your house is sold while during the listing term, you owe us the commission. You got to pay us. So, if we do have a listing, it's illegal for you as a real estate agent to solicit the business of another broker. So if they have a listing and you go contact that owner trying to get them to drop the listing with that company and then give the listing to you, that's against the law. That's illegal. Okay. It's also unethical. So that's easy to prove though. You know, so you should always ask people if the property is currently listed. Now, if the owner is the one that approached you, though, about listing the property because they're having issues with their agent who's not responding to them or doing something or whatever, well, you can start talking to them because they're the ones that approached you about it. And you could just tell them, hey, you could ask them to give you an unconditional release from your listing, but if they don't, you got to wait till the listing expires, and then you can come to me and list the property with me. Okay, but you should not be entering. You really shouldn't be engaging in those conversations. Now, this is not much of an issue anymore with the buyer's agents, though, because of that recent NAR lawsuit that now New Jersey put together all these requirements for contracts that are required. These exclusive buyer agency agreements or some sort of BSA, brokerage service agreement, is required now in New Jersey by law. It basically stipulates it doesn't matter if you're working with the seller or the buyer. You have to have a brokerage service agreement in place that stipulates who you're working for and what the rights and duties and obligations are of each party. The agent to the homeowner to the agent, the buyer or the buyer. Who's going to pay the commission, how much, and are they going to allow that commission to be shared or split with another agent? Okay, this needs to be spelled out. And what exactly are you doing in exchange for the money you're earning? All right. And what are the obligations of the homeowner? Well, the homeowner's obligation is not to list with another agency while it's listed with you and to work with you to try to sell the property. Now, a procuring cost complaint would be filed at the local realtors with the local realtors association, not the real estate commission. And that case is called that complaint is called the procuring cause complaint. It'll basically be listened now. It's basically now you're going to have a hearing with a panel of judges who's going to hear your evidence and your case that you're going to lay out to them of why you should be the one that's owed the commission. Now, these judges are nothing more than real estate brokers who have been brokers for X number of years, for a certain number of years, and they got training on how to mitigate these issues. So they're basically like real estate brokers acting as judges. But both you and the other agent, if you are members of any realtor association, if you call yourselves realtors, you're a realtor, you required to participate in this. Now, if you can't reach a decision, then you could turn around and sue. But now you're risking your membership as well in the Realtors Association. The Realtors Association doesn't want us suing each other. Because if real estate agents started suing each other all the time over bickering commissions and stuff like that, we'd look a lot worse in the public eye too. But under certain circumstances, we can sue each other. So, what or who is a procuring cause? It's when two agents are in dispute over the commission. Who's the one that's owed the money? The one that did the most work leading up to the sale. But that can be difficult to prove. So if you're the agent, you entered in an exclusive buyer's agency agreement with them, and they said that they were working with another agent, that's pretty good evidence to start out. And then you set up all the appointments and you show them the property, that's still pretty good evidence, even better for you. And then the other agent is the one that actually wrote up the contract. At this point, you would probably be the procuring cause because you're the first agent that worked with them and then showed them the property, and then to somebody else and they put the offer together with them. So you did more work than they did at this point. But the longer you wait, or the longer it takes for you to find out they're working with another agent, the more the other agent does, the less you become the procuring cause, and it becomes harder for you to win that case. That's why now we have these BSAs, the buyer brokerage service agreements. It makes it a lot easier. It makes it a lot easier because not only do they say that they're not working with another agent, they're supposed to notify you if they don't want to work with you anymore. This is a contract you sign with the buyer or the seller, right? They have to notify you. And when they go work for another real estate agent, that real estate agent is obligated to ask them in another buyer brokerage service agreement whether they are working with another agent or not. And if they just wanted to put an offer together on a property, they have to find out if another agent showed them that property. So they have to request a list from that buyer, all the properties that have been shown to them. And they request that list also from the other agent that they used to work for. And if that agent cannot supply a list because they didn't keep records of all the properties they showed to their client, you're not owed anything. Okay, it actually makes it a lot easier. So keep track of your paperwork and your clients, your brokerage service agreements. You have a client, you set up a bunch of showings and you show them a bunch of properties. Keep track, keep a list of all those properties you showed them. Because I've had situations before where I've got a buyer and I've been running around like a chicken with their head cut off, showing you properties all over the place and you didn't put it on anything. And then suddenly you disappear. You find out then you bought something, you put an offer together with another agent, the property that I showed you. Yeah. It's even worse when that agent told them to go find another agent to show them property so they don't waste their time. And then when you find that perfect property, come back to me and I'll write the contract. You waste that other agent's gas, time, and money. I've seen people do that where the buyer was their relative. So that's pretty muffed up, yeah. So I've dealt with it several occasions, not just with agents doing this, having their client, but I've dealt with sometimes clients that were working with more than one agent and they were dishonest to the agents.
Oh.
Yeah.
Can they do that? No, right?
And now with the buyer brokerage service agreement, it makes it a lot better because you're contractually obligated to me. If I show you a house and I can prove I showed you that house, and you end up buying that house before the expiration of buyer agent and buyer agreement expires, and you didn't cancel it in writing, you're legally obligated to pay me my commission.
But in generally, people, can they have like 2-3 real estate find the house? Can they have it?
Sure. Hey, let me read what you just said to me. Okay. I'm going to reword it in a way because these are business relationships. You guys want to hear for that day that I was talking about how I liken business relationships to personal ones. Okay. It makes it a lot easier to understand the business relationships this way. If you start dating somebody, would you want to know if they're married? So wouldn't you want to ask that question first? Are you married before you start dating them? Okay, so if you're a buyer's agent and you're going to start working with a buyer, wouldn't you want to ask them if they're already working with another agent or not? I would. Otherwise, you just told me that it's okay to date that agent, and they could date several other agents too.
Oh.
So you're okay with them all fooling around, those buyers fooling around with other agents. Now, me, you're going to work for me. I'm going to be working for you. The time and effort to work for you, you're going to dedicate yourself to me. Otherwise, I'm not going to work with you. Date you. Yeah. You see, I'm liking the relationships, you know. Now, can you date somebody who's also dating other people? Sure.
Yeah.
Just like that. Can a buyer's agent work with a buyer who's also working with other agents? Sure. I don't know why you'd want to. But sure you can. So I just a scenario that it's easy for everybody to understand.
Oh, okay. So means I know you gave me the example. So we can have more than one salesperson, the real estate person, to find the house, right?
Yeah. You're not sure where you want to buy. So you're looking at not just in New Jersey, but also in Pennsylvania. And you're looking anywhere in New Jersey. Well, even though I'm licensed to show you homes anywhere in New Jersey, I really specialize in the North Central area. So, like if you want to buy down in Cape May, I really don't even have a membership to the MLS down there. So I'm familiar with the area. And I'm traveling 2 hours or whatever it is just to show you a house, you know, and then 2 hours back, you know. So if you want to buy a house down there, you can work with an agent down there for that area. But in this area, you're going to be working with me. So on those brokerage service agreements, you could actually stipulate the areas that you're working with as their exclusive agent. Okay.
Oh, okay.
County names. Here, these are the counties I work in. And if you want to work with somebody else in those other areas, that's fine. Usually, if it's though, and I know about it, and they want to look at it, I'll tell them, I'll say, listen, if you don't have an agent in that area that you're considering buying down there, then let me know. I could find you an agent down there that's good, and I could refer you to them. So now I'll send them a referral agreement to that agent down there, so that they sell them a home. I'm still going to get some commission out of it. They're going to share some of that commission with me. Okay, so don't just let it go.
Because the reason I'm asking, my brother is looking for the house last 2-3 years. So he has one real estate guy. He's helping, but
not that well. I mean, for 2 or 3 years.
Yeah.
Questions or something. Oh, how come he hasn't been able to find him a home? You know?
So my question is, he's looking for some in other areas. So last time I said, why don't you find in this area? Do you have to stick with that guy? That I was asking, because I don't know how it works, the real estate thing.
I'm asking if he has a written agreement, a brokerage service agreement. They're required by law now too. So I don't know if they're still just operating off of with no written agreement. They're required by law to, if they want to a commission.
Mm-hmm.
So a lot of agents may not enter these agreements until they actually find your property, and then they'll bother to put it together. I suggest that before you ever even start your computer to open the MLS to search for homes for somebody, that you get a written agreement in place with them. Don't waste your time. Don't waste your time with people. Get it in writing. And then hook them up with a mortgage rep so that you could get them pre-qualified and then pre-approved for a mortgage. So you don't waste your time showing homes to people who have a 400 credit score. You know what you're buying with a 400 credit score? Nothing. Your credit sucks. Okay? You're not buying anything with a 400 credit score. So, but wouldn't you want to know that before you start running people around and showing them houses and setting up appointments and wasting your time? I remember there was a couple like that. They were a young couple. They seemed all legit. This was when I started working up in West Orange, up in the Oranges, and I was showing this couple so many houses. I wanted to help them. The means because but they got a baby on the way. I wanted to help them out. I really wanted to help them out. So I really showed them a lot of places, and eventually found something that it was actually pretty decent, that didn't need a lot of work in their price range. We go put the deal together. I get them on the phone with a mortgage rep at that point, because I'm putting the offer together, and we got to submit that with at least a qualification letter. So the guy runs the credit, and they had like a 500 credit score. It was an awful credit score. 620 is considered prime.
Right.
That's average. Okay. Anything below 620 is subprime. You could still manage to get a loan, but higher interest rates, and they're going to be required to put more money down. It may still be possible to get a loan. Let me say that. Down to as low as 580. Below 580, I don't think you're getting a loan. You're going to be getting hard money loan, which we're talking about really high interest rates, and you having to put a lot of money down. No.
So as a real estate, if you have your buyer who has low credits, that time what you do? You just gonna go away?
Get their financial house in order before they start shopping for an actual house. You're not ready. Even if they got even if they could get a loan, but their score is still really low, they're more likely to get a high interest rate, put down more money.
Right.
And I'm just going to give them a little practical advice. I'm going to be like, listen, I can show you houses and try to help you find a home and put an offer together and get you under contract here. But quite frankly, it's probably going to overextend you, and you're going to end up being this house
high
financial burden on you, and you may not be able to keep up with it. So it may hurt you in the long run.
Right.
I suggest you pay off some of your debts, get your credit score built up a little bit so you could get a lower interest rate and all that, and require less money to put down, all this. Save up more money so that you could put down, so you could borrow less.
Okay.
And then I suggest you come back. I mean,
okay.
I hope you shop for a house if I know that you could get the loan, but
right.
I suggest to buy a house at any time. You should have your finances in order before I start helping you actually buy a house. Okay.
Right.
I just have a straight up real conversation with people like that.
Of course, yeah.
Sometimes they don't like it, whatever reason. I want it now. I mean, you get people all the time. They buy cars and overpay for them at high interest rates, and because my credit sucks. They didn't even care what my credit score is. And then you tend to overextend yourself. You fail to make the payments, and then they repossess your car, and now you have a repossession on your credit report. So you're even destroying your credit even further. But the house is cheaper. It's going to be even worse. So I try to give people a little constructive help in that regard, because I've seen people destroyed financially because of this, so I try to help.
Yeah, in that case, they can better go for renting the house than renting the apartment or something for a while, right? Yeah.
Be a buyer either. Not everybody's meant to be a homeowner,
Right, of course.
Look, if you have a job, you got very low income, you're not trying to go for any of the low income housing or anything like that. There are programs that for low income people to be able to buy houses, but they're in low income housing. I don't want to call it a project, but they're housing places where you could buy low income housing, but you still have to meet certain income requirements and credit scores, and your debt shouldn't be too far out of whack to overextend yourself. So, I tell people, not everybody's meant to be a homeowner. Maybe you'd be better off being a renter, at least for now, until you get your finances in order. Improve your finances a bit, and then I could help you. Search for a home. But because you get people too, they have jobs, they have no plans on changing their jobs, and so they're going to stay in it. You get people always arguing. We need a living wage. Yes, you need to make $35 an hour, and you're not planning on leaving that job at McDonald's. It's not going to happen unless you become a manager, right? And if you don't plan on becoming a manager, it's not going to happen. You could give up your home ownership dream and settle down with being a renter. Okay, it's not about, well, bosses need to pay you more money so that you could afford. Maybe you go back, take some classes, learn to get a different job that will pay you more. Or you could rough it out and be one of these people that work 5 jobs. I know people who work multiple jobs. Home ownership may not be in sight for you. I got a good friend, they're a married couple. Their credit sucks. They used to own a house. It got foreclosed on them. They're really bad with paying their bills for some reason. And I've helped them move several times. Now I don't even bother. Now I'm like, I don't know. I don't know anybody like that. Most of the ones in the MLS, they require credit checks and this and that. You're better off finding a homeowner, renting. And so what they've been doing is they've been now like renting out places here and there. And every year it seems like they move because their credit, they're bad at paying their bills. It's like, are you going to waste your time? Even though they're good friends of mine, I'm wasting my time with them. I'm definitely not going to earn a commission on it, because they're not going to be able to pay me, and I wouldn't even want to ask them because they're my friends. So in that kind of a situation right there, I say I usually don't have a problem working with friends or family, but in that kind of situation right there, I don't want to be involved in. I'll be like, I'll keep an ear out if I hear anything for you. But other than that, I'm not putting a whole lot of effort into it, Okay.
Understandable.
Thanks.
Yeah. All right, so a meeting of the minds is when all parties are aware of and in agreement on all the terms of the details of the contract. Now, the school exam focuses on a little bit different definition because they focus more on the financial aspects. It's when the parties are in agreement on price, down payment, and financing method. That's the definition you need to know for school exam. Hint, hint. This is the definition you need to know for state exam. It's when the parties are aware of and are in agreement on all the terms and details of the contract. We're now here. We got a same understanding. We got a mutual agreement and understanding. We've come to a meeting of the minds. That's what a meeting of the minds is. Okay. But with the school exam, they really only focus on the financing of it. So it's when the parties are in agreement on price, down payment, and how you coming up with the rest of the do re mi. Okay. Yeah, so the financing method. Okay. Kickbacks are illegal. Okay. Before we even get into talking about any kind of kickback, kickbacks are illegal. Okay. So let's look at two versions of kickbacks here. Illegally giving anything of value to a friend in exchange for a lead. Let me ask you a question. Who can you pay? As a real estate salesperson, who can you pay?
The broker, right?
Broker.
Nobody. You're not paying your broker. Your broker pays you when you close on deals.
Oh, I misunderstood. Who can pay you? Nobody, right?
You broker.
Your voice
You
is
repeat
cutting
that,
off.
you broke up.
Okay.
Yeah.
Let's start off with the beginning. Who can you pay? Who can you pay a commission or fee to? Nobody. Nobody. That's your answer. No. Okay. Who can you be paid by?
The broker.
Broker.
Any broker?
Your broker.
Listen, if you got these basics down, it doesn't matter what kind of long-winded, complicated question they give you on an exam, you'll get it right. Okay? You just recall that question to yourself and ask yourself that question. Who can I pay? Nobody. Who can I pay? Only my broker. Okay, one more question. Who can your broker pay?
Me.
Any of their agents. That covers all the license types, right?
Mm-hmm.
They could pay another broker from another brokerage firm, like when they pay out a referral fee, because an agent from another brokerage referred us business, a client. We closed on the deal. I don't pay that other agent. They're not my agent. I pay their broker, and their broker then pays them. Because who could they be paid by? Only their broker. And who can a broker pay? Any of their own agents, another broker, or a buyer of a primary residence can receive a rebate. That's when we share a portion of our commission with a buyer of a primary residence. But we need to have that agreement in writing from the start of our business relationship that we're offering a rebate and how much that rebate's going to be. And then we need to let everybody know in the transaction that a rebate's being offered. Because depending on the type of loan program that buyer's getting, their lender could say no. They could say you can't get the rebate. And then that's beyond our control from there. But we can only give rebates to buyers of a primary residence. Primary residence does not mean your first home. Primary residence is the primary place you live. So if you have multiple homes, if you have a vacation property, or if you have investment properties, we can't give rebates for those. We can only give rebates on homes that you plan on living in. Okay, that's your primary residence. Where's your driver's license? What's the address on your driver's license? Where's the address on your tax filings? Okay, that's your primary residence. Okay. Let me finish this slide and then we're done for the day, okay? Or anything of value, giving anything of value to an unlicensed person or back to a seller, because seller rebates are illegal in New Jersey. Some states they're legal, not New Jersey. Only rebates to buyers are legal, but only certain kinds of buyers of a primary residence. And then you got to have it in writing. You got to let everybody know that they're offering a rebate, and you got to advise them to consult with their tax professional because they may have to pay taxes on that rebate money we're giving them.
Okay.
Okay. Now, buyers of a prime. So, can you give anything of value to a friend? Well, your friend's going to give you a lead, a buyer, or they know somebody's looking to sell their house. Can you offer to share a portion of your commission with them, or give them a couple bucks, or some kind of I'll give you a big screen TV if you refer them to me? No, that's illegal. It's a kickback. Okay, now buyers of a primary residence can receive a buyer's rebate, therefore it's not a kickback. But be sure to follow the laws regarding that. Okay, and I guess I already had that conversation with you guys. I didn't even realize I was there. Okay, so We already spoke about it. So we're pretty much done with this slide right here, but this is not a bad slide to snap a picture of and put that in your notes as well. Okay, we talked about meeting of the minds. You'll get an exam question on it. We got the school definition of meeting of the minds. You'll get a school exam question on it. You need to know what a kickback is, and the situation about giving anything of value to a friend in exchange for a lead, and rebates. You know how those rebates work. Who could get a rebate, and can we give them? We could give rebates only if our brokers allow it. And then we need to follow the rules about giving rebates legally. Okay?
Yeah.
When we gonna have school exam? When we gonna have exam?
After we finish the class and you finished all your chapters and all your hours and stuff, then you register on the school website for taking the school exam.
Mm-hmm.
And then I manually enter you into the exam system that we pay a third-party service for the exam system that we then, the exam's on our website. You take the exam on our website, but it looks like it's on our website, but it's actually being fed through a third-party software that serves it up securely. Okay, so in your browser, it may say this is unsecure, but it's actually secure because it's going through a third party that's just in a frame on our website.
Okay, so school exam is going to be online
On
from
our
home. From
Correct.
home,
Correct.
I see.
Correct. And even when we get to having in-person classes, eventually, we're going to start having them again sometime. I'm still going to be doing the remote exams. I'm not going to do them on paper anymore.
Right.
Because I could have a big database with thousands of questions for you to select from. So you could sit next to someone else and you're going to get a totally different exam than the person sitting next to you.
Right. Mm-hmm.
Yeah.
Mm-hmm.
And it gets graded automatically too. Less chance for human error and all that good stuff. All right. So let me stop this.